May I please, my lord? My lord, item number 28, my lord. The petitioner got full relief, my lord. So, my lord, I may be allowed to withdraw. Item 28.
Mr. S. Chauhan, learned counsel for the petitioner, submits that the read petitioner has got the relief and therefore he no longer wish to press the matter.
My lord, item number 19.
Just
my
a
lord.
minute.
Yes.
In view of above, the writ petition stands dismissed as withdrawn.
Hmm.
Yes.
My lord, item 19, my lord, is a new motion matter, my lord. I have misplaced the file, my lord. So, my lord, it may come on Monday next, my lord.
We're
Item
mixing.
19, my lord.
Registry will fix a date. Item 19.
Yes.
Mr. S. Chauhan, learned counsel for the petitioner, submits that he has misplaced the brief and prays that the matter be listed on Monday. Stop. In view of above, matter stands adjourned to be listed again after a week on a date to be fixed by the registry.
My lord, this is IA for restoration, my lord. There is a direction to list after summer vacation. So kindly tomorrow or day after tomorrow.
You approach the registry for that. If there's already direction, they'll list it. Okay. Yes.
Met the lordship. Lordship, item number 9 for today's list, my lord.
Yes.
I am on behalf of Mr. P.J. Soika. He is informed me by telephone, my lord. Matter taken up a passover for a day, my lord. His personal difficulties, my lord.
Mr. P.J. Saikia, please write down.
Yes.
Learned counsel for the petitioner is said to have personal difficulty to appear before the court today. Stop. On a prayer made on his behalf, matter stands passed over for the day.
Much obliged.
May I, Lord?
Yes.
Lordship, I beg to mention item number 29 and 30, Lordship. These two matters, Lordship, became infructuous, Lordship. That may be closed, Lordship.
Your good name?
AMS Majumdar.
Mr. A.M.S. Mozumdar, learned counsel for the petitioners,
Yeah.
submits that the two writ petitions have become infructuous. Full stop. Next para, in view of above, the writ petitions are disposed of as infructuous. Let it be a common order. 29 and 13. Yes.
Oh, Lord.
My pleasure. So beg to mention item number 10, your lordship. I am appearing on behalf of petitioner side, your lordship. Unfortunately, I have not met the party in Sheba board, your lordship. So I want to complete the party as Sheba board.
Your good name?
Yes, Islam.
On the prayer of Mr. S. Islam, learned counsel for the petitioner, the matter stands adjourned for a week to enable him to file appropriate application for impleadment of SEBA.
Sheba.
Yes.
I beg to mention item number 21, motion matter. In this matter, I need some instructions. So, may kindly be urgent for the day.
Yeah, Talukdar.
My lord.
Mr. A. Talukdar, learned counsel for the petitioner, submits that he needs to take further instructions from his clients and therefore prays for adjournment for a week. In view of above, matter stands adjourned for a week.
May I please? I beg to mention for listing contempt case only.
You approach the registry.
Moreover, I get to mention item number 34 and 35 on behalf of the big request.
Yes. What do you want?
The matter, come up of 3 weeks.
Why?
But
There was a DPC which is going to be conducted. DPC is going to sit where the cases of the petitioners will be considered.
Okay, but Pugasta is only for item 34.
Yes, 35 he has said that he has taken the consent. I am for the respondent, private respondent.
Okay.
He said that he informed the other side.
35 also is taking consent.
Same Lord.
On the prayer made on behalf of Mr. B. Prokasta, learned counsel for the petitioner in WPC number 2571 of 2023 and not objected to by the other side, matter stands adjourned for 3 weeks.
always.
My lord, with the consent of the petitioner, my lord, I beg to mention item 76 to 79, my lord. My lord, in this case, we are to file affidavit, my lord. The affidavit has been prepared and it is sent for vetting, my lord. Kindly give us
How much time?
2 weeks, my lord.
Your good name?
As das,
Mr. S. Das,
standing counsel higher education.
standing counsel higher education submits that the counter affidavit has been sent for vetting and he requires 2 weeks time
Please.
to file the same. To stop, he also submits that he has taken the consent of the other side. In view of above, list the matter again after 2 weeks.
That may be fixed after 2 weeks.
On a date to be fixed by the registry. Okay.
May I please, your lordship?
I beg to mention a WPC for listing. It was last listed on 14/7. But due to some personal difficulty, my senior was unable to.
You approach the registry. for listing.
I
Okay.
much humbly pray you to. be
No,
kind
no,
to
you
fix it.
approach the registry. This is what I'm passing the order. I'm not passing any order.
Much-
Yes.
May I please, your lordship, I beg to mention for item number 15 and 17 for adjournment, lordship.
15 and
17, 17,
what do you want?
adjournment, lordship. I'm
Why?
sorry.
You're for the petitioner.
Yes, lordship.
Why do you want adjournment?
Lordship, my senior's father-in-law has expired
Who?
last
Who's
week.
your senior?
Mr. Yamio Mandal, lordship.
Okay, Mr. M.U. Mandal, learned counsel for the petitioner, is said to be in bereavement. On a prayer made on his behalf, matter stands adjourned for 2 weeks,
1 week, lordship.
1 week. 15 and 17. Okay.
Obliged, your lordship.
Please, your lordship. Which I beg to mention a motion matter for listing a motion matter, lordship. Friday, identical matter speaks on Friday, lordship. Same issues, lordship.
You approach the registry. Okay, listing the motion matters.
May I please, lordship, I beg to mention item number 8. Your lordship, this matter has become infructuous. The petitioner has got the relief.
Your good name?
Yes,
Your name?
S. Chauhan.
You're for the petitioner.
We are for the petitioner. My senior is Mr. M. Sharma.
Miss S. Chauhan,
Yes.
learned counsel appearing on behalf of Mr. M. Sharma, the engaged counsel for the petitioner, on instructions submits that the writ petition has become infructuous since the petitioner has already got the relief. In view of above, the writ petition stands disposed of as infructuous.
Sure. May it be please, your lordship. Lordship, I beg to mention item number 27, lordship. Matter may be adjourned for 2 weeks, lordship. 27.
You want adjournment
Yes, lordship.
for 2 weeks?
Yes, lordship.
Why?
My senior is out of station.
Okay.
lordship.
Ms. K. Devi, learned counsel for the petitioners, is said to be out of station. Stop on a prayer made on her behalf. Matter stands adjourned for 2 weeks.
Lordship, I beg to mention item 7. This matter may be taken up after 2 weeks or 3 weeks because my lord, similar issue is pending before the division bench. And
You're for the petitioner.
Lordship,
He's right. Counsel for the petitioner submits that since similar issue is pending before the division bench, the matter may be adjourned for 2 weeks. To stop in view of above, matter stands adjourned for 2 weeks as paid for.
obliged.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 26, lordship.
26, yes.
I'm praying for a short date, lordship, in this matter, lordship. Maybe fixed after 1 week, lordship.
Why not today?
Some instructions were supposed to be before the court, lordship.
Okay, you're for the petitioner.
Yes, lord.
As paid for by the petitioner, list this matter again after a week on a date to be fixed by the registry. Okay.
Hello, Lord, this matter may come up for orders day after tomorrow.
What is that matter?
It's regarding Lord selection and appointment to the post of reader of the university. Lord, since Lord, matter is of 2021, stay order is continuing. It was
Please
supposed
approach
to-
the registry for
It
that.
was supposed
listing.
to come last week, Lord. So, Lord, since there is,
Please approach the registry. They'll do it.
Lord.
Alright.
Obliged.
May please, your lordship. Lord, item number 66, my lord.
Hmm.
The orders follows.
66.
66. Lord, I've informed the petitioner, my lord. Will require 3 more weeks time to, my lord, take further instruction.
You're for the respondent.
I'm for the respondent, number 1. He's for the petitioner.
I'm for the petition.
Hmm. 1 week,
3 weeks, my lord.
3 weeks for instruction. On the prayer of Mr. B. Kaushik, learned counsel for respondent number 1, and not objected to by the other side, matter stands adjourned for 3 weeks. To enable him obtain up-to-date instructions on the compliance of the court's direction.
Stop.
List again after 3 weeks on a date to be fixed by the registry.
For withdrawal item numbers 1 to 4.
May please, your lordship. I am appearing for item number 1, my lord. Item number 1, my lord. WBC number 42124. I want to withdraw this petition, my lord, with liberty to file a fresh matter.
Why liberty?
A subsequent development is there, my lord.
Then what about the other matters?
Lordship, item number 2, we have also instructions to withdraw the matter, lordship.
With liberty.
Uh,
All these cases with liberty.
So,
Lordship, I am for the 3 and 4 item number. Lordship, similar.
With liberty. So I just simply say that withdrawn with liberty to file afresh. Okay. As paid for by the learned counsels for the petitioners, The matter stands disposed of as withdrawn. Stop. However, liberty to file a fresh writ petition is granted as prayed for.
Appear for petition.
Stop. Mr. S. Bora, learned Standing Counsel, appears for the
BTC.
Standing Counsel BTC. Appears for the BTC.
J das for respond number 6 to 13.
And Miss J. Das, learned counsel, appears for, what is that department?
In the private assignment.
J. Das appears for the private respondents. Anyone else? All right.
For motion, item 5.
My please, your lordship. Lordship, my senior is on like another court. Lordship, matter.
So you do it. You take it up. What is the case? You're nervous? First time you're appearing before court. Huh? Then? What is the case about?
Lordship, area salary, lordship.
It's regarding area salary.
Lordship.
How much is the amount? Do you know? Figure is there. Main prayer is release area salary. Interim prayer also release area salary.
Lordship.
So there is no difference between the main prayer and the interim prayer.
11,82,356 amount. Your lordship, in this matter, notice should go, your lordship. Notice.
Art Mr.
M. Alam, lordship.
A.
M. Alam.
M. Alam, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondents for releasing the area salary of her late husband for the period from 21/5/2012 to 18/1/2014.
2014.
Stop. The learned counsel submits that, in fact, the petitioner had submitted a representation dated 26/9/2023 for release of the area salary. But since the same has not been considered, the petition is before this court. Next para, issue notice of motion returnable by 4 weeks. Ms. P. Das, learned standing counsel, Secondary Education Department, accept notice on behalf of respondent numbers 1, 3, 4, 1, 3 and 4. Then
Extra copy may serve the form.
who is there for finance? Mr. M. Bhuya, learned standing counsel, finance department, accepts notice on behalf of respondent numbers 2 and 5. I think it's complete, isn't it? Stop. Notice is therefore complete. Stop. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing for the respondents today within 2 days. Next para, list the matter again after 4 weeks. Stop. Pendency of the writ petition shall not be a bar for the respondents to consider the representation of the petitioner and also release the area salary.
Deeply obliged.
If possible, can the name of A. Chalina be recorded in the standing counsel? Because I'm not the standing counsel finance department. Can the name of A. Chalina be recorded?
Replace his name by A. Chaliha.
Must.
Item 6. Here, your lordship, DSC has, your lordship, deputy of director of secondary education has wrote down one letter, your lordship, to ISC, your lordship. Instruction is awaited. Although your lordship, in this matter also, your lordship, notice has not been issued.
Issue notice then.
Yes, your lordship.
Heard Mr. M. Alam,
Lordship.
learned counsel for the petitioner. Who submits that by filing this writ petition, the petitioner has sought for a direction to the respondents for payment of area salary to the period from 21/5/2012 to 18/1/2014. Stop. Next para, issue notice of motion returnable by 4 weeks. Ms. P. Das, Learned Standing Counsel, Higher Education Department, accept notice on behalf of the respondent numbers. Not higher education, secondary. On behalf of respondents 1, 3, and 4. Then Mr. A. Chaliha, Learned Standing Counsel, Finance Department, accept notice on behalf of respondent numbers 2 and 5. Notice is therefore complete. Petitioner to serve requisite copies of the petition to the learned counsels appearing for the respondents today, within 2 days. So this again after 4 weeks. Stop pendency of the writ petition shall not be a bar for the respondents to pay the area salary of the petitioner as claimed by him. Yes.
Item 11.
Content pilot to make the operative portion. Page 39, para 7 minor.
This is the first time, isn't it?
Pilot.
This is the first time.
First time.
Page 39.
Page 39, para 7 minor. May I read, madam?
Yes.
Though it prima facie appears that petitioner case is covered by the above judgment and orders, this court is of the view that by way of abandoned question, the state respondent should given the liberty to verify the particular petitioners. Accordingly, respondent shall verify the petitioner particular. If it is found that petitioners are entitled to the benefit provided under in para 118 of the judgment and order that so and so, same should be provided to the petitioner. The entire exercise should be concluded by the state respondent within a period of 3 months from that order.
This is a common order, isn't it?
Common order.
And your case is in respect of?
WPC? Old pension minor.
No.
Minor.
You're concerned with which writ petition? There are 3 writ petitions.
Yeah, yes, ma'am. Page 34, minor. Page 34.
Case number?
Case number 2948 2024.
2948 only, isn't it?
Mine.
Okay.
2948, minor 2020. Banikanto Moran and Nilimago, both petitioners came before lodge.
How many respondents? 2 respondents.
2 respondents, ma'am.
Okay, please write. Heard Mr. N. Bora, learned counsel for the petitioner. Petitioners who submits that. The direction of this court, right, common order dated 20/2/2025, passed in WPC number 2948 of 2024, has not been complied with by the respondents, despite a copy of the same having been furnished to them. We'll stop next para. Issue notice returnable by 4 weeks. The petitioner to take steps for service of notice upon the respondents by registered post with ADD within 3 days. List again after 4 weeks.
My lord, next case is also same, my lord, page 24, my.
Item 12.
Yes. Input, my lord, page 24. Menoka Dora, my lord. And operative portion page.
This will be in respect of WPC number?
WPC number 388 of 2020. Page 24, my lord.
They have filed separately.
Separate.
Okay.
Separate order was.
Same order, okay? Similar order. And only WPC number you change. WPC number 3888. 3888 of 2020.
Madam.
Remaining is same.
Madam. Order dated, my lord, on.
Order date also same.
No, 28 to 2025. 27 days.
Order date is also same?
No, madam. 28 to 2025.
I see.
28 to 2025.
Okay, the order date is 28/2/2025.
Item 13.
The respondents are to produce the report of the state level custodial committee.
I will put the report, your lordship.
The matter relates to the admission of the Jawahan over the Vidyalaya student.
Okay, I have flag marked and marked the revision portion.
May I have a copy of the report, ma'am?
Timothy Chaudhary has not produced any documentary and evidence to corroborate her linkage with any tea garden to establish that she belongs to the tele community under TBL, ex-TBL category. As such, the committee decided that there will be no further consideration.
Okay, last time submission was made that petitioner failed to appear,
Yes, Your
but
Lordship.
this shows that petitioner failed to produce. Did she appear?
Minus, that is not clear in here, but I have received verbal instruction that she has not appeared, Your Lordship. But here it is written that she failed to produce any relevant documents.
Okay. What is this community?
Lordship,
What is this community?
Lordship.
She belongs to, according to her, she belongs to which community?
Tele community.
Huh?
Tele community. Your
Tele
Lordship.
community.
OBC, Your Lordship.
OBC.
TBL, ex-TBL community.
So on the quota meant for OBC,
Yes.
she has sought for admission. Which
Yes.
which class? School? College?
School, yeah.
School.
She was studying with us for class 7, 8, and 9, I think. On the basis of interim orders passed, on the basis, interim orders was for her to appear in the year 2023.
No.
At that point of time also, she did not appear.
No, what I want to understand is
Yes, Your Lordship.
she has secured admission from the quota
Yes.
meant
yes,
for OBC.
Yes.
Okay.
She had applied as an OBC candidate on the basis of a certificate. It was subject to verification at the time of verification of all documents.
Class 8.
Yes, Your Lordship. It was class 8.
Class 6.
Class 6.
Class 6, Your Lordship.
So admissions are given on quota basis like that. And she applied for OBC.
Yes.
And the OBC certificate produced by her is under scrutiny.
Agreed to the certificate which she produced at the time of admission in class 6, and we told her to produce the original. It was some other, her grandfather's certificate or something like that, Your Lordship. Whereas we actually asked for the applicant's certificate. So therefore, she was asked to produce the proper the OBC certificate, which she could not at that point of time. They approached this honorable court. This honorable court, by way of interim orders, allowed them to study with us and said that you appear before the caste level, state level caste scrutiny committee, and you produce your documents, and on the basis of the report which they produce, it will be.
You're for the school.
Yes, Your Lordship.
Okay. Yes.
Now, on the basis of the interim orders, she has managed to continue to study with us under the OBC category
Since
for
when?
2 years.
Since 2
More
years.
than 2 years. More than 2 years now.
2 years. 2 years
And
means
even there's an interim order in this case as well. So she has still not been removed from the school because of the fact that this honorable court said that, okay, let us just wait for the finding of the SSSC.
but this writ petition is of 2025.
Yes, Your Lordship. The second time again they approached this honorable court. This is the third time. Second time on the day of the motion, without issuing a notice to us, they just said we should be allowed to go and appear before the SLSC.
This is the third round.
This is the third round. So a lot of leverage has been given to the petitioner. In fact, had it not been a child, I would have said that cost needs to be imposed on such kind of frivolous litigations. The father very well knows that he does not belong to this community. Why would they have managed to remove? They have taken away the one seat of an actual OBC candidate.
Okay, we'll do one thing.
Lordships.
We'll list this matter again on sometime next week. You get your instructions and we consider it for final disposal on that.
The session has started and she's again studying with us, Your Lordships. If Your Lordship will vacate the interim order, one child may perhaps be accommodated in her place.
That cannot
That
be done
is-
because the person, they were already admitted in class 6. So
Now
now
he's
at
in
this
class
stage,
8.
at this stage, not a fresh, no one will be admitted through a
How would he-
written test.
That is for the authorities to
No,
decide, Your
because
Lordship.
the JNV curriculum says so. Lord.
It is for the authorities to decide.
In class 11 and 12,
Class 9, the remaining seats, which are the balance seats, are always sent out again. That is also in this curriculum, what he's talking about. And in any case, that should
that is
not
in
be
class 9, she is in class
in
8.
any case, that should not be his lookout. His
I leave it to your
petition
lordship,
before
but-
Your Lordships was that he should be allowed to appear before the SLSC. That was the only prayer before this honorable court, which he has done, and the report has come that they're not eligible to be, they have not been able to produce any documents to prove their this.
Okay. We'll do one thing, like I said, we'll list this matter on Wednesday next and give him a copy. You file this by way of an affidavit. one affidavit, covering affidavit for this. We take it up on Wednesday. All right. Miss R. Dekal, Learned Standing Council, Social Justice and Empowerment Department, has produced the minutes of the SLSC dated 14/7/2025. To stop, let a copy of the same be filed by way of an affidavit. Release this matter again on so and so Wednesday, 30th July 2025.
May I pray for continuation of the interim?
Sorry?
May I pray for continuation?
Our interim order shall continue till the next date.
All right, sir.
14.
My Lordship, my senior counsel engaged in court number 6, Lordship. Senior counsel engaged in court number 6, Lordship. Kindly pass over for time being.
This is for admission or orders? This is motion. Who is Miss? Where's Miss Kanwar? Respondents?
Yes.
Mr. Diori,
Yes, sir.
any instruction?
Instruction has been received, Your Lordship.
In view of the order dated 13/10/2023, what is 13/10? What is this matter?
Matter relates to completion of the funds.
Huh?
So don't know, na? 14.
14.
This is regarding compassion appointment, is it?
Senior.
Yes, Your Lordship.
No.
So here to that on perusal of page 24, Your Lordship. So the petitioner is not there.
Speak of the OM.
Yes, sir.
Documents verified. But because of the OM, they could not hold the
Yes,
DSC.
that is what this says.
Uh,
That is what this is. But on that, maybe on perusal of that page 24, once, Your Lordship, 24,
24.
page 24, page 24.
Yes.
Yes. Your Lordship, the petitioner says that the deceased expired in the year, the petitioner's husband, father expired in the year 2002, Your Lordship. So therefore, that first, second, third, as the matter relates to harness, Your Lordship. First, second, third, they did not apply. If the harness was there, they could have applied. Even the wife could have been earlier, this 20 years, 23 years back, Your Lordship. These are the now fourth, the next of kin that put Samina Begum Lasford. She has come. Do not meet the harness.
So? Number 4 has applied.
Yes.
That is a petition.
Number 4.
So what is wrong in that?
No, if harness is there, then the other 3 elders could have applied because there is no bar for them to apply.
No, there's no bar, but.
Yes, yes, Your Lordship.
But if they don't apply, is there any bar that?
That means harness is not there. Harness is not there. The very concept of the scheme, that harness and immediacy, that is absent, Your Lordship. Because as per whims, they had applied. This says that yes, they had preferred application in their synopsis. They says that some dates have been given, Your Lordship. But on the perusal of the next of kin.
When was the thing filed, the application? When did the husband die?
Husband died in the year 2002. Now the daughter is coming, but father died in the year 2002.
Father died in 2002. And application filed on?
Application filed on day says that from the year 2008.
2008.
2008, 9.
By the present petitioner. By whom?
Page 28, Your Worship. Page 28. Page 28, by the present petitioner.
So case of the petitioner is that application was filed in 2008,
Yes,
but since then it has not been considered.
yes, yes. So, that, it can be in the next SLC, but kindly that observation be there, Your Lordship, what I had prayed for.
Heard, Mr. Your good name?
Suddin on behalf of Kemira.
Huh?
Suddin on behalf of Kemira.
S. Sudhir.
Suddin on
S.
behalf of Kemira.
Heard, Mr. S. Uddin.
Suddin.
Learned counsel appearing on behalf of Mr.
Kemira.
K. Mira for the petitioner.
Lordship, just one. Lordship, matter has not been considered in the DLC. It will again be reverted into DLC only.
Exactly.
Yes.
It will go to DLC. Who submits that by filing this writ petition, the petitioner has sought for considering her case for compassionate appointment in terms of the application submitted by her on 27/5/2008. To stop, the learned counsel submits that the father of the petitioner died in harness on 14/5/2002. And since she was a minor during that time, she could not apply for appointment. Subsequently, on attaining majority, she submitted her application in the prescribed format on 27/5/2008. And thereafter, on 25/6/2009, 17/2013, 25/9/2020, 6/8/2021, and 25/9/2021. But since her case has not been considered by the district level committee (DLC) Hailakandi, the petitioner approached this court by filing WPC number 6067 of 2023. Stop. The writ petition was disposed of by order dated 13/10/2023, directing the respondent number 4 to verify the petitioner's application and thereafter place the same before the next available DLC Hailakandi for consideration. However, no, cancel it. However, the petitioner was directed to appear before the Assistant Commissioner Hailakandi and Executive Magistrate Hailakandi on 23/9/2024. Along with all original documents and certificates. To stop, the petitioner appeared as directed, but her case could not be placed before the DLC Hailakandi in view of the office memorandum dated 18/9/2024. Stop, aggrieved. The petition is before this court. Stop, next para. when the matter was listed on 23/6/2025, from our court directed the learned government advocate to obtain instructions as to whether such verification had taken place or not. Stop. Today, Mr. B. Dury, learned government advocate, submits that as per the instructions received by him, verification of the documents indeed took place on 23/9/2024. But in view of the office memorandum dated 18/9/2024, the case of the petitioner could not be placed before the DLC Halakandi. To stop, the learned government advocate also submits that from a perusal of the next of kin certificate, there is no annexure number. Is it a part of annexure 1? Okay. Next of kin certificate, it appears that there are 5 members in the family, including the wife of the deceased government servant. To stop, the petitioner appears to be the 3rd eldest daughter amongst the 4 siblings. Stop. Therefore, the elder siblings of the petitioner could have applied for compassionate appointment if the petitioner was a minor at the relevant time. To stop, he therefore submits that there is no immediacy he cancel that, he therefore submits from there, okay? The learned government advocate thus submits that there is no immediacy involved in the instant case, and that the application has been belatedly submitted. Stop. Be that as it may, since it has been ascertained that the documents of the petition had been scrutinized, verified on 23/9/2024, and that solely on the ground of the OM dated 18/9/2024, the matter could not be placed before the DLC Halakandi. And therefore, having regard to the direction passed by this court earlier on 13/10/2023 in WPC number 6067 of 2023, the respondents are directed to place the case with the petitioner before the next DLC Halakandi for consideration. The petition accordingly stands disposed of. Anything else?
Just at page 28, Your Lordship, page 28.
Yes.
Just to draw that your lordship will notice that it was application preferred in the year 2008.
Eight.
From 2008 to 2021. The signatures are the same of the recipient. That is one, just one. And more so on perusal of that page 43, your lordship, page 43. Page 43. We'll see that in reference, the district commissioner's Hailakandi letter number such and such dated 19/9/24. Taking that as an handle, there has called for all of the 35 persons. But we had sent specific letter asking for that particular document, district commissioner Hailakandi letter dated 19/9/24, but that was not being. So whatever, just to highlight the matter. Okay. Oblige.
Item 16.
May it be pleases you, lordship. Your lordship, in this matter, your lordship, we needed to file one affidavit, your lordship, regarding the subsequent development. So your lordship, kindly grant us 10 days time, your lordship, to file that affidavit.
Additional affidavit has been filed.
No, your lordship.
That has not been filed, lordship.
We're awaited for that decision, your lordship, that has needed to be taken, your lordship. Which has already been taken, your lordship, that instruction is awaited, your lordship.
This is for which post?
Lordship, junior assistant.
Some anomaly was there in the typing test.
Lordship, it was alleged that some anomalies were there. And that's why result was not declared. And on the earlier direction, lordship, the honorable court has issued clear direction that if no anomalies are found, then let the result be declared. But that has not been done. And in fact, nothing anomaly, they have not provided any specific anomaly that this happened. So they are not specific about it, lordship. And also they are not declaring the results also. And a contempt is also pending, lordship. I have submitted in the last date. So lordship was pleased to hear the matter and issue status quo and bring into record the decision taken, that is by letter dated 28 to 2025. They have stated that they have taken some decision.
Your lordship, your lordship, pertaining to that, your lordship decision, your lordship, we are needed to file our affidavit, your lordship.
When will you?
Thereafter, your lordship.
When will you file?
Your lordship, 10 days time may be granted to us, your lordship.
There's an order passed on 28 too.
Yes, your lordship.
To go for fresh selection. Or what?
Fresh selection. Earlier selection is cancelled, your lordship.
So that you want to bring on record?
Yes, your lordship.
Why should you require 10 days time? Because he had already mentioned that in 25/6. On 25th of June, court was informed about that.
They have informed, but lordship, the copy was not given to us. We were supposed to get a copy and we'll file immediately, but we have not get a
Okay.
copy.
So we'll grant them some time. Status quo will be maintained.
Your lordship, next day, your lordship, status quo, your lordship, prayer may be accepted, your lordship. Let us bring our affidavit in.
No, it's already accepted last time. Today also will continue.
Your lordship, your lordship, I'm praying for your lordship.
No.
Short date, your lordship, 7 days, your lordship, one.
But status quo will remain.
About this.
As paid for by Ms. P. Das, Learned Standing Council, School Education. Further, 1 week time is granted for filing an additional affidavit in terms of the order dated 25/6/2025. Stop, list the case again after a week on a date to be fixed by the registry. Stop, additional affidavit should be filed within 1 week. Stop, status quo shall remain till the next date of listing.
DPO list. 18.
May it please your lordship.
Yes.
This matter pertains to admission into first year MBBS BDS courses, my lord. My lord, the admission process was initiated by issuing a notice dated 7th of February 2025, my lord, by National Testing Agency, my lord, NTA, as per the provisions of the National Medical Commission Act. The state government also, for the seats of the state, has a common test along with that test, my lord. The state has no other independent test for admission into MBBS BDS courses. In this regard, my lord, state has issued a notification in the year 2017, my lord. That is last page of my read petition, my lord.
How many petitioners are there?
Single, my lord.
Then why do you write petitioners everywhere?
Only petitioner, my lord. Petitioners, not petitioners.
You have written petitioners, that's why I'm questioning you.
My lord. I'm
Huh?
sorry for that, my lord.
It's not me who is saying that there are petitioners. It's you who is saying petitioners.
Yes, my lord, I am sorry.
Synopsis also says petitioners. Now, what is the problem?
Problem is that, my lord, in the year 2024, the state of Assam has amended the rule for admission into first year MBBS BDS courses, my lord.
What is the rule otherwise?
Otherwise, my lord, the name of the rule is that, my lord.
Is there any provision governing the admission to MBBS?
Yes, my lord.
What is that provision?
That rule has been issued by the government of Assam, my lord.
What
This
is that?
Called the Medical Colleges and Dental Colleges of Assam Regulation of Admission into First Year MBBS BDS Courses Rules 2017. It has been amended in the year 2024, my lord. That is, I have annexed, my lord. I have annexed it at page, my lord, 40 as annexure 8. Whereby the schedule 3 under section 6.
First of all, you show me the unamended rules. Unamended rules.
Fundamental rules, my lord.
Not fundamental rules, unamended rules, the original rules.
Yes, my lord, that is in force, my lord. I am challenging amended in the year 2025, my lord.
He wants to see the Oh, please understand what I'm saying.
Yes, my lord.
There is a provision for admission, rules governing.
Yes, my lord.
Where is that rules? Have you annexed it?
My lord, particular provision which was existing at the time of admission, my lord, before this amendment, my lord, I have annexed, my lord. That is at page 8, my lord, 40, my lord, annexure 8. Relevant portion is at page, my lord, 47. At page 47, my lord.
This is the amendment.
My lord, earlier amendment, my lord.
How many amendments are there?
3 amendments are there. One in 18. Second one is in 24, and last one is 25. I am challenging 25 on the basis of this amendment of 24, my lord.
See, it would have been better if you had gone step by step. This is the rules of 2017.
Yes, my lord.
This is first amendment, second amendment, this is third amendment.
Yes, my lord.
And what is the offending part in the third amendment? Then you point out like
Yes,
that.
my lord. My
Straight away, you're going to the amended 2024.
Because my
How will the court understand?
Because, my lord, my offending part is only this one, my lord.
Oh,
My lord, in that case, my lord, I am not annexed the whole rule, my lord.
I'm asking you about the transition from earlier it was like this, thereafter it became like this. today it's like this, and because of this, I've been prevented.
Yes, my lord, I understand your lordship.
You should have explained that.
My lord, I want to submit that this provision was introduced in the year 24 only, not prior to that, my lord.
Okay, that is why to understand what has been introduced, what was not introduced,
Yes,
you
yes.
should take me to the original act, original rules.
Yes, my lord. In this case, in this regard, my lord, may I pray another item has fixed on 28, my lord. In similar issue, my lord.
Item 28.
No, my lord.
On 20th
On
of this
20th
month,
of this month, my
Uh-huh.
lord. This matter also may be
similar matter has been fixed.
taken up along with that matter, my lord.
That is lordship read.
Case number
Case number, my lord,
3866 of 2025.
3866
66 of
Yes, lord.
2025. It is fixed on lordship.
on 28.
28/7 2000.
28th of July.
Okay, as paid for by the counsel for the petitioner, list this matter along with WPC number 3866 of 2025.
Highly obliged.
Oblige, your lordship.
20.
Yes.
First of this matter relating to compassionate appointment lordship with a limited clear lordship to place the SLC lordship. Like if kindly see the DLC recommendation page 24. Page 24 type copy.
DLC dated
DLC 31/12/22.
31/12.
Yes, lordship, 22.
Why have we come in 25?
Lordship, no lordship, there is a court order in the event of the OM came into field lordship. This for this OM dated 18/9/24. Case was not placed. Now the court is directed to consider. With that prayer have come to place in the SLC lordship. Kindly see page 24, DLC resolution lordship. Page 24.
What I'm saying is that if you were recommended by the DLC
Yes, lordship.
in the year 2022,
Yes.
why are you coming to this court after 3 years?
Lordship, prior to that, I also came before this court. Court is directed to consider my case. That is case lordship.
This is the second round.
Yes, lordship. Case 20 is the first order lordship. Case 20, WPC number 5481. That was not communicated lordship. This DLC. Case 20, WPC 5481 and 11% lordship will file case 22. Case 22. Case 22 lordship. Last two paragraph. Case 22. Mary lordship. Case 22, last two. As the petitioner on 30/11/22 again applied for her appointment on compassionate ground through the local MLA, the DLC for compassionate appointment, the wrong forwarded the proposal to the petitioner, government for consideration as reaction. Since the DLC for compassionate appointment, the wrong height already recommended the name of the petitioner to the government for consideration, noted above, the petitioners got relief as prayed for in this writ petition. For the reasons noted above, this statement does not call for any further adjudication with regard to the prayer made by the petitioner. Now, lordship, this is the order, and this DLC was not communicated to me and informed to the court that DLC already recommended. That recommendation is page 24, lordship. Dated 31/12/22. In the meantime, the OM dated 18/9/24, page 29, lordship, that came by which it was decided not to hold a DLC meeting, lordship. Then a number of persons approached this honorable court challenging this OM lordship. The honorable court by order dated page 42, lordship, similar order passed in WPC 2070/25 by order date 34/25, page 43, directed.
Just a minute. Let me read.
Yes.
You were recommended by the DLC Darang
Yes, Lordship.
on 31/12/2022.
Yes, Lordship.
Then
Then, Lordship, in the meantime, the OM came, Lordship. Page 29 dated 18/9/24, by which the government decided not to hold any meeting further. Then that OM was challenged in a several ways of litigation, and the consent order has been passed, and court has directed to consider all the pending cases. Now my case is pending. I'm with a prayer to consider my case on merit, Lordship, in the SLC, Lordship. I have
yes, Yuri,
That can matter since it's of 2016.
please write down. Heard Mr.
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioner, and Mr. B. Diori, learned government advocate, as well as Mr. P.K. Bora. Four respondent numbers, 1 and 4. To stop having regard to the projection made by the petitioner, the writ petition is taken up for disposal at this stage. Next para. This is the second time the petitioner is before this court. The earlier writ petition, being WPC number 5481 of 2022, was disposed of by order dated 23/1/2023. After the court was informed that the case of the petitioner has been recommended by the district level committee bracket DLC Darang in its meeting held on 31/12/2022. Stop. However, despite the recommendation made by the DLC Darang, the case of the petitioner has not been placed before the state level committee bracket SLC for consideration in view of the office memorandum dated
18/9/24, page 29.
18/9/2024, wherein it is provided that in view of the introduction of compassionate family pension scheme, in case of compassionate appointment, in respect of the employees who died in harness after 31/3/2017 will not be considered the petitioner being aggrieved is again before this court. Next para. Facts of the case in brief is that the mother of the petitioner died in harness on 22/12/2016. And at the relevant time, the petitioner was a minor. On attaining a majority, she applied for compassionate appointment, but the DLC concerned on two occasions, that is 31/5/2019 and 31/12/2021, had rejected her case on account of late submission of application. So, however, the petitioner again submitted an application which was duly considered by the DLC concerned, and she was recommended for consideration for compassionate appointment by the DLC Darang dated 31/12/2022. To stop, the office memorandum dated 18/9/2024 provides that provides for the cutoff date as 31/3/2017. Whereas the mother of the petitioner expired on 22/12/2016. Stop. A number of cases pending before this court on the same issue was taken up for consideration. With WPC number 342 of 2025 as the lead case. To stop, this court provide common order dated 3/4/2025 disposed of the writ petitions by directing the respondent authorities concerned to consider all pending cases in terms of the relevant scheme formulated by the state government. To stop, the case of the petitioner is therefore squarely covered by the said decision. And that the office memorandum referred to herein above will not apply to the case of the petitioner, having regard to the date of death of the deceased. Stop, in view of above, the writ petition is disposed of with the direction to the respondents to place the case of the petitioner before the next SLC meeting for considering her case for compassionate appointment. The petitioner calling stands disposed of.
Nothing. Your receipt may be taken after some time being 22 and 23. Same. 23. Same.
24.
Yes.
Matter relating to constitution of ad hoc school management committee by replacing the existing managing committee, petitioner was selected as the president and vice president and member of the SMC as per the general meeting of the parents of the students. Accordingly, the said SMC was approved by the DO. Your lordship will find page 27 approval order. Page 27. This is the committee approved by the district.
Page number?
Page number 27. 27.
Yes, what is this?
Yes, this is the approval committee, whereby my petitioner and petitioner number 1 and 2 other petitioners was selected as the president, vice president, and members. Accordingly, first meeting was held of the SMC, and thereafter, suddenly the DO.
Just a minute. By this page 27.
Yes.
The school managing committee has been constituted.
Yes, my lord.
How many petitioners are before this court?
6, my lord.
6.
Yes, sir.
All of them? All the members?
All of, my lord, petitioner number 1 is the president, petitioner number 2 is the vice president, and others are the members.
Members.
Yes, sir.
Can you just tell me from this page 27, who are they?
Yes, my lord.
Basadin Sheikh is?
Basadin Sheikh is the petitioner number 1 is president.
Petition number 1. Then?
And Sakinak Bibi is the petition number 2.
Yes.
The vice president. And
Then?
thereafter, next page, 28 minute. Rashida Bibi is the member, petition number 4. And Nur Islam is the member, petition number 3. And Amina
Roy
is the petition number 5.
5.
And Mojida Bibi is the petition number 6.
So total 6 petitioners.
Yes, 6 petitioners.
And by this
approval order. This is the approval order.
Approval given by the DO.
District Elementary Education Officer. Lordship will find page number 28.
Yes.
Below portion, my lord. As D eligible, District Elementary Education Officer, 24/10/2024.
Officer is not there.
My lord.
Officer is not there. District Elementary Education, that much.
Sorry, a minute. Type it is, my lord.
This is a type copy of it.
Yes, madam, type copy, madam. This is a type copy.
Okay.
My lord,
This is dated 24/10.
Yes, my lord, that is.
Then what happened?
Yes, my lord. Thereafter, my lord, the DO
Hmm.
issue a communication to the all members and as well as the president, saying that a hearing will be conducted in his chamber regarding the reconstitution of the SMC of the said school. Your lordship will find.
Reconstitution.
Yes, my lord.
Why?
Why, my lord? At the time of hearing, the petitioner came to know that some students of the member of this SMC has passed out from the school, my lord. Some students of the member of the SMC has passed out. So he wanted to reconstitute the SMC in place of the existing committee. That is not permissible, my lord. There is a procedure of dissolution of the SMC, my lord. If they wanted to dissolve the committee, there is a procedure and certain conditions, my lord.
Yes, what is that? What is the provision?
Provision is, my lord.
Under which provision?
Yes, my lord. My lord, I am referring the rule, my lord.
Yes, rule, which rule?
Some
Assam
Right of Children Free and Compulsory Education Rule 2011, 11, my lord. 11, my lord. Your lordship.
Rule 11.
Yes, my lord. Page number 260, my lord, in this book, my lord.
216.
260. 260. Yes, sir. And there is a notification also in pursuance with the rule, my lord. Your lordship, and this is the.
Dissolution of SMC.
Yes, my lord. This is the provision, my lord.
So this was not followed.
Yes, my lord.
What is the precise provision? Rule 6.
Rule 6, my lord. As per this rule, my lord, if the SMC could not perform the duties or fail to perform the orders of the department, then, my lord, members, guardians of the parents of the school may adopt the resolution for dissolving the SMC. Moreover, DO directly may dissolve if the SMC is failed to perform the power and function and follow the order of the department on inquiry, my lord. In this case, my lord, nothing has been done, my lord. Moreover, if so, resolution SMC is dissolved, and within the 1 month from the date of the dissolution of the SMC, committee should be constituted. Here the ad hoc committee was constituted for the 3 months, my lord. Your lordship will find page 261, my lord, in this book, my lord. District Elementary Education Officer, my lord, last middle portion, my lord. Rule 6, Roman 6, my lord. District Elementary Education Officer shall take the step for constitution new SMC within 1 month, within a month of dissolution of the concerned SMC, my lord. And here, my lord, ad hoc committee was constituted for the 3 months. There is no any provision in this rule for constitution of the ad hoc SMC, my lord, by replacing the existing committee. There is no rule. And the impugned order, your lordship, kindly see.
The SMC can be dissolved.
It can be dissolved.
By following certain procedure.
Yes, my lord.
And after dissolving within 1 month,
yes,
a new SMC,
should be constituted.
In your case, you were dissolved without this procedure, and ad hoc was
yes, ad hoc committee
was constituted.
With some officials. Here, my lord, in the impugned order, nothing has been mentioned about the ground of the ground of the constitution of the.
Let us come back to your petition.
Yes, my lord.
You have shown me page
Yes.
27.
Yes, my lord.
Thereafter, meeting was called.
Yes, my lord. Meeting, hearing was called.
Hearing was called on page 30.
Yes, my lord. Page 30, my lord. This is the communication 11/6/2025 and hearing was scheduled 17/6/2025.
Where you called also in this,
My lord.
where the petition is called.
Yes, my lord.
Where is that?
Yes, call for, my lord.
Where serial number?
Yes, serial number 4, my lord.
These all members of
All members of the,
Lakura ME school.
yes, my lord, all members. All
Members means what?
Members means my SMC members, my lord.
It doesn't say SMC.
Yes,
It just says members.
yes. They did not say SMC members, but all members, my lord.
Okay, then
Thereafter, my lord, hearing was conducted in the chamber of the DO, my lord. And in the hearing, the petitioner came to know that some students of the member of this SNC has passed out. That's why he wanted to reconstitute the ad hoc committee.
is there any bar?
My lord, no, there is no provision for constitute ad hoc committee.
No. I mean, no, regarding keeping the ad hoc committee aside, you are saying that the reason behind is that some students, some children of the members had passed out.
Yes, my lord.
Is there any bar?
Now, passed out, there is no bar.
Then
Usually they will pass this is the procedural, my lord.
see, the children of the members cannot study in that school.
My lord.
The children of the members, SMC members,
Yes.
they cannot study in the school or what? Is there a bar?
It is the provision, my lord, the children of the member
Cannot study.
Should study.
Should study.
Should study.
Okay, then
Then should study, then the parents of that said student may be a member. It is
can be a member.
Maybe be a member.
Right.
That's why the guardian of the student is selected as the member, my lord. Some student, all the students of the member has not passed out, my lord. My information is the few students. For that reason, entire committee cannot be dissolved, my lord. And cannot reconstitute the ad hoc committee.
Okay.
You should kindly see the impugned order.
I'm trying to understand
Yes.
your submission. You are saying that the students, the children of the members
Yes,
have to study.
I have questioned.
If they pass out, then they cannot
There
remain,
is no provision, my lord.
they cannot remain as a member.
But there is no,
According to the DO.
according to the DO. But there is no provision in that rule, my lord.
I understand that.
Yes, according to the DO.
What the DO thinks is that since some of the students of the members have passed out,
Yes,
so they should be replaced.
yes,
Okay.
yes. That is his assumption, my lord. But entire committee cannot, my lord. Here the president's student is studying, vice president student is studying, all the petitioners students is reading. Why the entire committee can be dissolved, my lord?
Okay.
My lord,
They are
kindly-
still studying.
Yes, my lord.
So there is a misconception.
Yes, my lord.
Okay.
Thereafter, my lord, you kindly see the impugned order, my lord.
Where is that page number?
Yes, my lord, page 32.
32.
32. Nothing has been mentioned the reason why the ad hoc committee has constituted, my lord, without dissolving the earlier existing committee, my lord. There is no any whisper about the dissolving of the earlier committee. Just they have constituted the ad hoc committee, replacing the existing committee, my lord. That cannot, my lord. There is no any provision, my lord, for constituting ad hoc committee, my lord. If committee is dissolved, new committee should be constituted within 1 month from the dissolution of the committee. Why the ad hoc committee for 3 months, my lord? My humble submission is that impugned order may be stay, my lord.
Okay. Yes. Madam, you're appearing.
First of all, ad hoc committee was considered only for 3 months. This is not a temporary arrangement. This is not a permanent arrangement.
Even then,
Another thing is that maybe some complaint against that SMC. So I may be allowed to take instruction.
you
why-
take instructions, but there'll be stay.
No, my lord, why they had constituted they are going to constitute a ad hoc committee. So my lord, I may be allowed to take
You
instruction.
take instructions, but you see the provisions.
maybe complain against the.
Dissolution of SMC is possible. Please listen, dissolution of SMC is possible as per the provisions under this rule 12, sub rule 6. Hmm?
With the officers, they have constituted the ad hoc committee, not any other person, my lord. They are all officers, block elementary education officer, JE engineer, JE engine office, SSA Dhubri, Subhat Das, they are all officers, my lord. Not
Why the
other
officials,
person.
my lord? There is a
Maybe-
democratic committee is there, my lord.
Maybe some complaint, maybe. other
Maybe
things.
complain, my lord.
So you find out.
So with the department, my lord. So sometime maybe allowed to.
Let them bring instruction, my lord. In the meantime, my lord, the
No, my
interim
lord.
or improved order may be stated, my lord.
This is the only temporary arrangement, only for 3 months.
If rule is not
So-
permitted, my lord.
Please listen. Show me in the provision where there is a provision for temporary SMC. Ad hoc SMC. There is provision. If there is no such provision, then
No, hearing this, no, hearing from. Well, another thing is that the PO. One hearing was done, my lord, so the outcome of the hearing also immediately.
you are Mr. Islam.
R. Islam.
Art Mr. R. Islam, learned counsel for the petitioner, who submits that by filing this petition, the petitioners have challenged the order dated 9/7/2025, bracket annexure D, D for Delhi, by which an ad hoc committee of Lalkura ME School has been constituted by the District Elementary Education Officer, Dhubri. To stop, the learned counsel submits that the petitioners are the
President, vice president and members.
president, vice president and members of the said school
Said assembly.
of the said school managing committee,
Yes.
bracket SMC, which was constituted and duly approved by the District Elementary Education Officer on 24/10/2024. Full stop. However, the District Elementary Education Officer
My lord, on 17/6/2025.
Summoned
a
a-
hearing was done, my lord.
summoned I know, summoned
For that reason, they have constituted, I think.
I know,
They are going to
madam, let me dictate. What did I say? District Elementary Education Officer called for a hearing on 17/6/2025 by inviting the officials as well as the members of the SMC. Stop. Pursuant to the hearing, the impugn order constituting the ad hoc SMC committee has been issued by the said authority. Full stop. The learned counsel, by referring to Rule 13, bracket 6 of the Assam Right of Child to Free and Compulsory Education Rules, 2011, submits that a specific provision for dissolution of the SMC has been provided. Full stop. However, the District Elementary Education Officer, without following the said provisions, has constitute an ad hoc SMC committee for the school. Of the Learned Council therefore submits that the impugn order dated 9/7/2025 should be set aside. Next para, in view of above, issue notice of motion returnable by 4 weeks. Miss
M. Fukan.
N.
Fukan.
N. Fukan, Learned Standing Council. Elementary Education Department accepts notice on behalf of respondent numbers
1 to 4.
1 to 4. Stop petitioner to serve requisite copies of the writ petition to the Learned Standing Council within 2 days. Stop petitioner to take steps for service of notice upon the respondent numbers 6 and 7 by registered post with ADU within 3 days. Next para, having regard to the projection made by the petitioner. The impugn order dated 9/7/2025 shall remain state till the next date. This is the matter again on so and so. Let's give a date.
Deeply obliged.
29.
Item 72 of the supply list for motion.
My lord, in last, my lord, HSLC exam.
In this case, my thesis is on election code number 1, after some time.
Which is item?
Item 72, my lord, supplementary motion.
Who is appearing for this?
TC Sutia, my lord. I am doing the
TC.
SBT department, my lord.
Mr. TC Sutia, my lord.
He is what? He is the SSB council.
Yes,
My lord.
Okay, let him come. Last time also we had adjourned it because of him only.
After
But
some-
it has not been reflected in the cost list, isn't it?
My lord, not reflected.
Was supposed to be.
About the matter.
My lord,
But he knows about the matter.
My lord, I have informed the about the matter. My lord.
Okay. He's on legs, let him come.
My lord.
Right. We'll pass it over for the timing.
73.
My lord, I am appearing on a caveat for respondent number 4.
Oh, is this that case?
That case. Possibly your lordship had an occasion to hear my learned friend, my lord, I was not there here.
Hardly, because you were not available that day, so we had just adjourned it.
Yes. My learned friend may start, my lord, thereafter I'll.
My only case, my lord, the page 16 where my body was constituted and I was placed as a president. And at page 20 is where I have been removed. The period was for 5 years. And my lord, and if before 5 years I have to be thrown out, reasons to be recorded in writing. I find there is nothing in reasons recorded in writing, and that no natural justice was given to me. And that on that basis, I have given a judgment of this court as regards reconstituting, assuming I am the most worst person in this art, but at least I should be given an opportunity. That was not given. And in the case that I have submitted before your lordship, the same thing was also there. That argument was placed in that judgment that he misappropriated a lot of money, but still then this court held natural justice and reasons to be recorded in writing should be there. That is my case, madam. Yeah.
Page 16.
My lord,
Page
page 16 where I was constituted and I was thrown out by page 20.
No, see, let us understand 16 first.
16.
You are what?
I am the president.
President
Educationist of Barkhetri College. President educationist for a term of 5 years or before 5 years for a term to be recorded in writing
He shall, however, continue this period till his successor is appointed.
No, president of the governing body.
Governing body.
President of the governing body.
Body under the Assam government, non-government college management rules.
How many members are there?
Members are below, my lord. They are, members are not here. I am only the president. I have been removed.
No, the body means only, it cannot be constituted by one person.
My lord,
there'll be.
I have been removed. Another president has been placed in my place.
Oh, I understand
My
that.
lord.
First of all, you tell me you are the president of the governing body.
My lord.
And the governing body comprises of how many members?
My lord, they are at present from A to K. They are members, my lord. Your lordship will find at page.
And this is constituted under what rules?
Under the Assam non-government college management rules.
Let us see the rules. 2009.
My lord.
Is it available in this book?
My lord, it is there. 37. Section 3, composition of governing body.
Page number?
439. This book, you also will find this book. One president, one secretary, the vice principal, ex officio member.
439.
439 page. This book, my lord, you also will find this. Oh, this book, same book. 439.
But this is the Assam non-government college management rules.
My lord.
Non-managed rules.
My lord. And section 3, composition of governing body.
Anything to do with the amendment? Rule 5 and 6 have been amended.
My lord, 5 and 6 is amended, my lord. My lord, 5, your lordship will find taking over the management of a deleted college. In event of mismanagement of the affairs of a deleted college, the state government may take over the control and management of the college for a period not exceeding 6 months and make arrangement for the management of the college in such manner as may be considered necessary, and the arrangement so made may be extended for further period by the state government as may be deemed necessary. And 6, accountability of the governing body. The governing body constituted under Rule 3 shall be responsible for the proper financial management, including the upkeepment of the assets of the college and management of its academic affairs. The governing body shall see the teachers perform their duties in classes and examination, attend the college for norms of the University Grant Commission. A self-appraisal report regarding performance from every teacher shall be obtained annually by the governing body for the same to the Director of Higher Education for perusal.
You have been you have been appointed.
My lord. Composition of the governing body is 3.
As per the provisions of 5 and 6, is it?
My lord. And the president, your lordship, will find A, educationist for a term of 5 years, or before 5 years for reasons to be recorded in writing.
Where is that?
Page 16, A, Roman, A, your lordship, alphabetical A, page 16, left-hand side A, president. Educationist, he should be an educationist for a term of 5 years or before 5 years. Or, the word is or. My term is for 5 years or before 5 years for reasons to be recorded in writing. I should be given a reason for removing me. And I was, if I could say, his appointment is on 26 August 2021 for 5 years. And my name is Dr. Raman Talukdar, Principal, Retired Haju College.
See, we'll come back in 5 minutes. Okay.
Wait for a second. Wait, to the lordship. I take your lordship to page 16 of my writ petition. Page 16 of my writ petition, your lordship will find. Then I will take your lordship to Rule 3 after amendment and Rule 4 after amendment.
Mr. Chaudhary,
My lord.
your page 16 says Rule 5 and Rule 6.
My lord, Rule 5 and 6.
This is the basis of your appointment.
My lord, yes.
5 and 6.
4 says tenure of a governing body. What I want to place it, your lordship may look into the rules.
Sorry to interrupt, Malab, there is an amendment to the rules. May I just place the amended rules?
That amendment I have taken, but this book contains the amendment.
Compendium, Malab.
Let us see the amendment.
That was done in the year 2017. Malab.
It is not here available in this book.
Malab, my book is different. Malab, I am not sure about that. Your lordship can look into this.
Your lordship may compare the 17 rules with the rule.
এটা না, এটা না, আমারটাও দিয়ে দিয়েছি
My lord, rule 4 after the amendment in the 17, my lord, your lordship may look into it.
কাগজ ঢুকাই দিচ্ছে এটার মধ্যে। আচ্ছা।
Rule 4, tenure of the governing body. May I read it slowly, madam?
Yes.
The governing body shall be a permanent authority. Its member would have tenures as provided. So what is provided in page 16? It was for 5 years. This would, however, not affect the permanent nature of the said body, provided that if the director is satisfied at any time that a particular governing body is not functioning in the best public interest, the director may suspend a governing body and appoint an administrator who shall exercise the power of the governing body during the period. The director shall record his views with reasons thereof through a speaking order for the purpose. It was same in what was in 2009. Your lordship may look into the book where I have given the same thing. And taking over, my lord, your lordship will find in the event of mismanagement of the affairs of the college, the state government may take control and management of the college for a period not exceeding 6 months and make arrangement for the management of the college in such manner as may be considered necessary. An arrangement so may be extended for a further period with the state government as may be deemed necessary. Now the question comes, my lord, reasons recorded in writing tenure of a governing body, which is the permanent nature, and the minimum member of a governing body is 10 and shall not exceed 12, shall not exceed 13. Now it was previously 12, now it is 13. Rule 3, subclause 2. The minimum members of a governing body shall be 10 and shall not exceed 13. In 2009, it was 12, now it is 13. My whole case is, my lord, what is the reasons? Where is the reasons? And my lord, administrative order cannot go beyond the natural justice. There may be in the statute or may not be in the statute. And this is not an appointment on a doctrine of pleasure. This is sheer a director who appoints it from the prescribed procedure laid down. And my lord, page 20, your lordship will find page 16 and page 20, where your lordship will find.
See, this page 16, it says 5 and 6. I don't know why 5 and 6 has been incorporated.
My lord, they are saying accountability of the governing body, 6 I have no relevance. Taking over the management of a college, 5 have no relevance.
No relevance.
4 is only tenure of a governing body.
Tenure.
Tenure.
Otherwise, under what provision can appointment be made?
My appointment under 3.
Under 3.
3.
Okay.
Your lordship has got it?
Yes, got it.
Every college affiliated by the central or state government of Assam and duly concurred by the state government shall be governed by governing body. Composition of the governing body. The governing body shall consist of one president who shall be an eminent person from the field of education. He shall be appointed by the director of higher education and shall have a term of 5 years.
Okay, let's move on from page 16. After page 16, what happened?
My lord, then page 20.
20. Yes.
So another person has been appointed here.
In between, nothing happened.
In between, nothing happened. I don't know anything.
No proceeding.
No proceeding, no natural, this is nothing, no show cause, nothing.
And this Sumanta Thakur,
He has been placed as the president.
he's a party here.
My lord, I have made.
You made him a party?
He is a.
He is for number 4.
That's for number 4.
My
Okay.
friend is appearing for him.
4. Okay. This is from which date? What is the date?
Date
1/7/25.
1/7/20. And that judgment that I have given, Malak, it lays down the ratio, where it was a case of a secretary who was removed, and the allegation was misappropriation of fund. Still then the court held, Malak, that natural justice and the reasons to be recorded in writing.
Okay.
Paragraph,
Okay.
Malak, that-
Okay. No, before that. So by this impugned order, only the president,
Malak.
others remain same.
Malak.
Now, one thing I've seen here, there's a notification mentioned in the beginning. Notification of the government. Powers conferred 9th of July,
Malak,
2009,
that
and one is,
amendment of the Assam
oh, these are the amendments.
amendments.
Then a notification of 24/4/25.
24/4/25, the undersigned as per
What is this?
provision.
What
These
is
are the
this?
amendments, Malak, college management rules,
24/4/45 is also amendment.
amendments. Some portions of the total rules are somewhere this way, that way, some things were deleted.
The order has the approval of the government by so and so 36. 25 by rejecting, by replacing the
Existing president governing body of the college, Sri Raman Tanakla. So he was only replaced. Malak, my only case is I may be the worst man on the earth, but that procedure has to be followed.
you are there to be you are to be there for 5 years.
5 years, from 21
to 26.
Or otherwise before 5 years to be recorded in writing, reasons to be recorded in writing.
And that judgment you've given me,
Of a secretary of a managing cooperative, page your lordship will find, para 11. Then my lord, para 14. And my lord, para 16 and para 18.
Maneshan নাকি? মানেশ্বর বাবু।
এটা কি পড়লো? কোথা থেকে পড়লো? আমার থেকে পড়লো না?
কোর্টের কথা আমরা কোথাও
এটা কি? পেটে যাবে।
একটা করে নেই লাগবে কথা। লজ্জা যেন কারবার হয়ে গেছে।
this judgment is regarding
Secretary of a governing body.
ex officio secretary,
Secretary.
principal and ex officio secretary of governing body.
But even in this orders where we are constituted and reconstituted, your lordship will find B is the secretary ex officio, the principal of the college.
B means
A, B, serially, A, B.
Where?
In page 16, your lordship will find.
Oh, 16.
Page 16 and 20 also. A, B. B is secretary ex officio. The principal of the college becomes the secretary.
Your case is principal and
My
president.
case is president.
And the judgment is regarding secretary.
Secretary.
So same ratio applies.
Ratio.
Okay.
And my contention is this: prior to that, my lord, your lordship will find, I have informed the authority about the earlier, my lord, principal who was having a lot of misappropriation of fund, and for that reason, a speaking order was passed removing that principal. Page 23, your lordship will find.
Before you.
Before me, I made the complaint.
Somebody else was there before you.
Not about the president, some principal of the college who was the ex officio secretary.
I see. Who was it? What's his name?
My lord, there in the second line, Dr. Bhaskar Koli, the principal. Page 23, your lordship.
Bhaskar Kalita.
He was the ex officio secretary.
Ex officio secretary.
He was
of this which college?
Same college. Borkhetri College.
Borkhetri College.
My lord, as a president, I made a complaint against that secretary regarding misappropriation of fund and administrative mismanagement of the college. And through a speaking order, he was removed by the authority.
By this order at page 16,
My lord.
this Bhaskar Kalita also was appointed.
My lord. My lord. During that time, page 21.
Borkhetri. You're the principal of
Retired principal.
retired principal of Hajo College.
As an educationist,
and the and the, what do you call, the ex officio secretary appointed was Bhaskar Kalita of Marketry College.
Who was removed?
But some complaints was there regarding him and he was removed.
And I made the complaint.
You made the complaint.
That is in that particular order, it was there.
So Bhaskar Kalita is removed.
Removed.
And now the guns are aimed at you.
My lord?
Now the guns are being aimed at you.
My lord, my lord. That may be the-
He has been shot.
He's been shot also.
Sure.
But it's not
Somehow,
fatal till
I'm
now.
in a coma.
You're
I'm in
in
a
a-
ICU in a coma.
You're in a coma.
That day, that Prince of Saudi Arabia, after 20 years of coma, he expired. You had met an accident and he made succumbs to the injuries after 20 years, and one is a coma for 20 years.
With all this medical help, I don't know how life can be prolonged. For a commoner, it would have not been possible.
No, impossible. But beyond imagination.
So that is the sum and substance of your
Sum and
case.
substance of my case.
You are appointed 5 years tenure, and suddenly they give you this order saying that you are replaced.
And to
And there's no
replace,
proceeding.
for replacing me, there should be a reasons to be recorded in writing. That is there in the page 16.
Appointment order.
Appointment order.
But in the rules itself, is there any provision for removal?
Yes, yes, my lord. The rules, my lord.
Which rule is that?
My lord, your lordship will find
3-4.
3-4.
3-4.
3-4. 3-3 and 3-4. 3-3 and 3-4.
Or which rules? I don't find any.
This amendment.
Oh, in the amendment. Okay.
Yes, your lordship.
3-3.
3-3 and 3-4.
Just read. What does the 3-3 say?
The president of governing body of colleges shall be an eminent person from the field of education. He shall be a non-political person. He should not have contested any election during panchayat, municipality, local bodies election, and should not be an office bearer of
Okay,
physical-
but Mr. Chaudhary, this is qualification.
And number 4.
Removal.
Rule
Regarding
4. He shall be appointed by the director of higher education and shall have a term of 5 years. He shall, however, continue beyond this period till his successor. The director may, however, remove him any time during the term of 5 years for reasons to be recorded in writing. 4-4. Your lordship has got it? For a reasons to be recorded in writing. That was inducted in 2014 itself.
This was not there in the original.
It was there, man. Your lordship will find. Tenure, your lordship will find. Tenure of tenure of governing body, last line. The director shall record his view with reasons thereof through a speaking order for the purpose. Proviso to 4, section 4 in the book. The provided that if the director is satisfied at any time that a particular governing body is not functioning in the best public interest, the director may suspend the governing body and appoint an administrator who shall exercise the power such to record his views. The recording of reasons is a mandate.
Okay.
And that should definitely follow.
Before amendment, it was under section 4.
And this is.
After amendment, it's under section
Section
3, subsection 4.
4.
Okay. So your case is that reasons was not recorded.
And my lord, no show cause, no opportunity given to. Maybe the worst person on the earth. That's my submission. My friend will continue.
Mother, I am for the newly added president of the governing body.
Yes.
Now-
You are appearing for?
Respondent number 5.
Oh.
Sorry, 4th. Respondent number 4.
Oh, you are the new.
Yes,
So you
I'm
had
the-
filed caveat.
Yes, I am the
Okay.
new incumbent who had filed a caveat.
Okay.
Now, here is a case, my lord, as I can find out. The petitioner is an honorable man in an honorary post. And he wants to know the reasons of his perceived dishonor. It's an honorary post. It is not a.
No, is he not entitled to know why he's been replaced?
Now the rules say that he can be removed, replaced, subject to recording of reasons in writing. I am sure, my lord, the reasons, if your lordship will issue notice and call for the records, my lord, reasons will be there in the records, in the official file. The rules do not say that the reasons have to be communicated to him. There are two different aspects, my lord. One is requirement of communicating to him the reasons, and second is existence of reason. It only requires the departmental head, that is the director, to record reasons in the support of the decision that he wants to remove somebody or replace somebody. If your lordship will issue notice to the respondent, official respondents, certainly they will come forward with the reasons. Today, the question is falling for your lordship's consideration is, the order was passed on 1st of July.
Yes.
And today, assuming that, my lord, it is the day of first motion, my lord, it cannot be anything beyond 21st of July. So, an order passed on 1st of July, whether it calls for an interference by way of an interim measure, that it has to be suspended or stayed, so as to put him back to the position of the president. That is the consideration of the Honorable Court, in my respectful submission. Because ultimately, whether the order is sustainable or not, that has to be decided in a full length proceeding. Today, it is only calling for consideration as to whether there is anything to be stayed or suspended. Well, 20 days have passed by after the order has been passed. It has taken effect. I have assumed charge, my lord. I have also held a meeting of the general body. I have been presiding over the meeting. Now, the clock, hands of the clock, my lord, at this point of time cannot be turned back to put him back in the position. And ultimately, if your lordship does that, it will amount to giving him final relief at the interim stage.
So we'll examine this aspect. Who's for the department?
My lord, my only prayer was the status quo order. If he is holding the post, there is no problem with him. But also status quo will continue. That much will be there. Because there is a status quo. If he is holding or I am holding, whatever it is, status quo will be there.
If your lord,
my lord, if he cannot oppose because he is saying that he is having a position. I am saying I am not handed over the charge. Let there be a status quo. Why you want the my lord, your lordship will hear. Today is 25th. 21st I was appointed for 5 years. The hearing comes on 27th. It case become infructuous. Who will repay me? He will give an indemnity bond. That
where from the question of payment comes in an honorary appointment, that I will understand.
Your lordship will find. Then the government can appoint an administrator to run. That the rule provides such. The administrator can run the college. Why he wants to continue? If it is illegal, ultimately found, what relief I will get? What relief I will get? Let the status quo order continue. I am not asking for a stay.
My lord, first of all, my lord, it's an honorary post. The reliance my learned friend is trying to put on the judgment of this court, my lord, that is in respect of the principal, which by virtue of his office, he becomes an ex officio member. In case of president of the governing body, my lord, that is not the case.
My lord, my submission, Menoka Gandhi has said, if the statute does not provide, it will be there. Natural justice cannot be override in any circumstances. When the reasons to be recorded in writing, that doesn't mean that it will be with them. They will not show me the reasons why I have been thrown out. How could that be a concept?
Why he is feeling that he has been thrown out, my lord, I fail to understand, because it's an honorary appointment.
Has to be continued, my lord.
And if he wants a status quo, my lord, if your lordship had passed the order of status quo on 21st of July, that is on last Monday.
Yes.
If he wants that the status quo should relate back to 21st of July, my lord, that is his choice, my lord. I cannot oppose to it.
No, see, that may be, but the thing is that day, I think the order is that status quo as on date. As on date of the order.
That is 21st July.
One says that he has not handed over charge. So the other one says that I have assumed charge.
My lord,
so whatever it may be,
my lord, there is no question.
That will continue and we'll perhaps
Fix it just after 10 days.
We'll have a consideration of this thing at the earliest.
My lord, may I just make one submission?
And today, let me ask the government also what they have done.
My lord,
Whether-
may I just make a submission?
Yes.
If your lordship is considering, he has said that he has not handed over charge. My lord, in a situation like this, in a case of this nature, my lord, there is no handing over or taking over of charge. It is simply like that, although he has enclosed one sheet of paper with writ petition indicating that when he assumed charge, he had formally accepted it. But there, the scheme of the thing is that it is not incumbent, it is
What
not.
will be the problem, my lord,
It is not
is-
dependent on somebody assuming or handing over charge.
Okay,
So
okay.
this is one thing.
See, on the other hand, if you, according to you, you have assumed charge, you even haven't, you even have called the board of directors meeting or whatever. So process is going on. So how does that status quo affect you?
I'm not saying anything.
Then?
My lord, if your lordship is considering
So,
that
status quo is,
As on 21st.
status quo is such a word which can be interpreted by both parties. One says that I have not, one says I have. So
No,
this,
that's why-
this kind of argument goes on and on.
No, that's why I am saying, Lord, if your lordship observes it.
So that is why what I'm intending to do is that I'll issue a short notice. A short date will be fixed.
Records will be
Affidavit will be filed, records will be called, and court will take a decision.
And the status quo order.
So that the interest of the college does not suffer.
Yes, and at the same time, Lord, if your lordship is repeating the order of status quo as on 21st of July,
Yes.
the lordship may also kindly observe that it will not give him a handle to create a chaos in the college.
Why should why
No.
why that should be?
That-
If anything happens, let them file an FIR.
That
no,
your lordship, because otherwise,
Why?
because as a matter of official course, my lord, I am in the position of the president. Tomorrow I'll go to sign some records in the capacity of being a president because I have been working from 1st of July. He will come and he will create a chaos. Well, the interest of the college will suffer.
Well, let the administrator be
Some-
appointed.
some-
Administrator be appointed. Why
Some
he will not?
decision has to be taken. Some
Then,
decision
my lord,
has to be
no indemnity bond, nothing of that sort. He wants
And-
to continue and the
and-
case become infructuous.
And first of all, your lordship will kindly consider what is his right. He is
My right,
holding-
even my lord, in a doctrine of pleasure, but if I am thrown out also on that, the recent judgment says reasons has to be given.
No,
And
recent
reasons
has-
has to be submitted to the person who have been thrown out. Even if it's an appointment of doctrine.
Okay, tell me, how soon can the pleadings be exchanged?
Well, as far as my statements are concerned, my lord, I am ready today, my lord. I am
No,
ready
no,
today.
that cannot be. We need the records also.
That is, my lord, that is for the government.
That is
and that's
why, that is
for the
why.
government to come
Both
forward.
sides are private parties. The government has to come up with something.
Records, my lord. If it more than affidavit, the records is necessary.
And here is a case, my lord, there is no question of putting a status quo after the person has died on 1st of July. That
No,
will amount to, my lord, giving.
No. We have not said that status quo is on the date of the impugn order.
No,
That
I'm asking on 21st.
that we have not said. Status quo was as on the date
On the
when it was
21st,
last
that's
listed.
21st July.
So if according to you, you have already taken charge, you have taken charge.
So
There's no
that
issue
will
about
continue,
it.
man, nothing more. I'm not asking about status quo ante.
Well, that can save his face, my lord, that's a different thing. But technically, my lord, it is.
All right,
it
you
will
say
be-
that, you're aware about that, then you save the argument for the last day. See,
Yes.
I just want to know who your government side. Hmm. Okay, you file an affidavit and you produce the records. Don't give me that now.
So the law where working in two colleges is not permissible.
You file your affidavit and you produce the records. We take it up for disposal on the next date fixed.
Well, the council should also place the law where a person cannot be a president of two colleges. Let them show the law.
No, if he cannot place it, then it will go to your benefit.
Well, only by making an argument will not. Every argument should suffice with some legal principle.
Okay, please write. Will issue notice. Heard, Mr. PK. Huh?
Asking me that question. I'm not challenging or asking status quo order. I'll place the time of.
No, we are asking you to file your affidavit and
record-
produce the records. That'll be fine enough. That'll be good enough. Heard, Mr. PK Roy Chowdhury, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 1/7/2025, bracket annexure 4, by which the petitioner has been replaced by the respondent number 4 as the president of the governing body,
Bor Khetri College.
Bar Khetri College in the district of Nalbari. Of the Learned Council submits that the petitioner was appointed as the president of the governing body, right order dated 26/8/2021, bracket annexure 1, for a tenure of 5 years. Stop. It was also provided that the term of 5 years can be shortened, subject to reasons to be recorded in writing. Stop. The Learned Council submits that without any such reasons and without giving any opportunity to the petitioner, the impugned order has been passed by replacing him with respondent number 4. Stop. The Learned Council submits that the same is clearly in violation of the terms of the appointment, as well as
Rule 3.
Rule 3 within bracket
4
of the Assam provincialized colleges and Assam non-government college management rules, 2001, bracket as amended. Next para. In view of above, issue notice of motion returnable by which time can you produce? Sorry? 3 weeks time.
On the record, my lord, or if I need to produce a record within 10 days.
The records will suffice the issue.
Returnable by 10 days then, okay. By 7/8 of, oh, just a minute, what is 7/8?
Yeah, let it be 8th of August.
Friday, 8th of August is a Friday.
Okay.
Friday. Something like that.
No, we'll go beyond that. We'll have it on 13th.
Well,
returnable by 13th of August 2025. Okay. Mr.
Yes, sir.
S. Das, Learned Standing Counsel, Higher Education Department, accepts notice on behalf of respondent members. One and two. Well, Mr.
I'm for respondent number 4. 4.
Mr. Datta.
Yes. Yes.
S. Datta, Learned Senior Counsel, assisted by G. Sharma, appears for respondent number 4.
On caveat, Milord, that your lordship.
Bracket on caveat. Stop. Hence, caveat stands discharged. And what about 3?
Principal.
This notice steps will have to be taken.
Well,
Number 3.
Can it be by justice service?
3 and 4, isn't it? No, sorry, 4 you are appearing. 3.
4 I will sub copy to my friend my lord. 3 my lord through justice service.
Petitioner to serve requisite copies of the petition to the learned counsels appearing today. Stop. Petitioner shall take steps for service of notice by Dasti only.
For respondent number 4, I'll sub my copy to my friend my lord. And for number 3, I will through justice service.
Through Dasti only, not registered.
No, through this.
Okay.
Registered post also, simultaneously registered post.
Okay. Petitioner to serve notice to respondent number 3 by registered post with AD due. Stop. Additionally, petitioner is allowed to serve notice. Respondent number 3 by way of Dusty through the registry of this court and thereafter file an affidavit as proof of service. Stop. Next para, having regard to the nature of the case and the projection made by the parties, the matter calls for an early adjudication. Stop. Accordingly, the learned state counsel, the learned counsel for the department shall produce the relevant records on the next date fix, on which date an attempt shall be made to final dispose of the writ petition. Okay.
Until then, my lord, the status quo order will come.
The status order, which was passed on 21st of July, shall continue till the next date.
God bless you.
$74.
273, no? Yes.
Lordship, I have an aspirant for the MBBS and BDS courses, my lord, in Assam. I am a PRC holder of Assam. I'm a permanent resident of Assam. My lord, my father is serving in the Indian Air Force as an Air Force officer. My lord, he was involved in the recent Operation Sindhus, though that term has not been specifically used in the, my lord, petition, because there's an instruction, my lord, that we cannot use that term. This is solely for lordship's permission, my lord. May not be retained in the records.
Yes.
My lord, that is why this term has not been used, my lord, in the petition. My lord, this operation, my lord, even though the incident was over, but the operation has been continuing, my lord, even as of now, my lord. And the petitioner's father was actively involved, my lord. He is in the signals unit of the Air Force, for which, my lord, he has to monitor. And my lord, there are certain technical issues which, my lord, I have been instructed not to. But
I did not.
My lord. So therefore, my lord, up to 16th of July, he was on active duty, my lord. He could not even come out of the base. My lord, that is why a certificate which is required, my lord, for applying to the MBBS courses, that could not be obtained up to 16th of July. That the petitioner could obtain only on 17th of July. My lord, there is a notice because, my lord, in Assam, my lord, there's a special quota for serving defense personnel and children of ex-servicemen, my lord. There are 9 seats in the MBBS course and 3 seats in the BDS course in the government medical.
We're concerned with what?
With MBBS and BDS. My lord,
Both.
till now the counseling is not over.
Both.
She would apply for, my lord, she would
Both.
apply for MBBS and that would be her first preference.
9 MBBS seats.
And 3 BDS seats.
Three.
This is as per the 2025 rules. And also I have given a list, my lord, at page 37. This list is from the website of the Department of Directorate of Medical Education, my lord.
This is reserved for?
Reserved for the special quota for ex-servicemen and serving defense personnel children.
Together.
Together.
Ex-servicemen serving.
Yes, it's one quota, one category in the special quota.
Yes.
My lord, there is a notification of 1st of July, my lord, whereby, my lord, the persons applying under the special quota, they have to submit their applications within 11th of July. My lord, this notification, my lord, is at page 74.
$74.
74.
Yes.
Applications are invited from candidates seeking admission to the first year MBBS BDS courses in the Government Medical and Dental Colleges of Assam, session 2025 under special quota. These are different quotas. We are concerned with the second last one, my lord, in the line below, ex-servicemen and serving defense personnel. The application form for the above mentioned special quota will be available in the on the office website, DME so-and-so, and filled up form along with all relevant documents as per provisions of the MBBS BDS Admission Rule 2017, amended up to date, must be submitted in the office of the undersigned, it's given, my lord, on or before 11 July 2025 during office hours by hand. No further application will be considered by this office after the last date of submission, that is 11 July 25. Applications sent by post, email shall not be considered. So, my lord, it's only in the physical mode the application could be submitted. I could not submit it by post or by email as given in this particular notice.
There's a specific format.
Yes, my lord, it's at page 75.
So your case is that the application could not be filed within time.
My lord, that is my case.
Now, what is the quota? Anything to do with the quota?
My lord.
Anything to do with the quota, ex-serviceman quota? Service.
For this particular quota, it's 11th of July. The counseling has not yet started.
And for others?
My lord, it will start from tomorrow.
Not counseling, I mean the last date of admission.
It has to be in the merit list, my lord.
No, the last date for submitting the application has to be 11th of July.
No, only for the special quota.
Only for the special
Only
quota.
for the special.
Others have different dates.
It is only for the special quota. And my lord, they have published a revised merit list, my lord, in which there is no person from the special quota under the defense category. My lord, I did not annex it, my lord, because this is 422 pages. But I have gone through, my lord. If my lord may retain it, my lord. There is no one, not even a single candidate. I have made specific government to that, my lord.
There's no?
Not even a single candidate from the defense quota, either ex-serviceman or serving, my lord.
Okay, only one.
So
the present
petition is
petitioner.
only one.
But it's belated.
Belated, my lord. And the certificate which is required, my lord, to be submitted, that I have already annexed, my lord. It is to be, my lord, signed by the commanding officer of the unit, my lord. My lord.
Where is that?
My lord, at page 86. Oh, sorry, my lord.
83.
83, my lord. 83. This is as per the rules. As per the 2017 rules, my lord. Page 83, my lord. Certificate of reservation of son, daughter of ex-servicemen serving defense personnel hailing from Assam. Certified that so-and-so. It's a commanding officer of the 820 signals unit where my father is posted. And Lordship will see the instruction. Certificate without signature of both the authorities officers shall not be accepted. Competent authority in case of ex-servicemen is Director, Sainik Welfare, Assam. And competent authority in case of serving defense personnel is the commanding officer of the concerned unit of Army, Navy or Air Force. So, my lord, without this certificate, I cannot submit. And my lord, I obtained this certificate, my lord, I could obtain it only on 17th of July.
Why? Why is that?
My lord, because my father was not let out of his duties, my lord, up to 16th of July. There's a certificate to that effect, my lord. At page 82. Page 82, my lord. Well, this is 19th of July. This is a fact that Group Captain Sunil Kumar Pandey, Commanding Officer, Air Force Station, Tiwari Tala, Prayagraj, is on posted strength of a very important specialist communication unit of the Indian Air Force. The officer was involved in recent operations of national security. My lord, deliberately, the term has not been used. Therefore, the officer was not relieved from duty till 16th of July, 2025. This is the reason why, my lord, she could not obtain the certificate. And she could obtain it on 17th. And my lord, 18th of July was a date fixed for document verification. She had come along with her father to the office, my lord, for to request the authorities to accept her application, along with all the certificates and other relevant documents. The authorities, my lord, expressed their helplessness. I have my father also submitted a representation on that day, my lord. Page 85, my lord, is the representation. The type copy is at page 84. Was given by hand, not handwritten. Page 84 is the typed copy. Respected sir, I want to bring to your kind notice that my daughter, Ms. Prerna Pandey, has cleared NEET 25. However, missed the filing of application under special category of XS. This is ex-servicemen and serving defense personnel due to my nature of job. So I, along with my team, was completely involved in the recent operations, which our country witnessed on May 25. Due to my nature of job and position, I couldn't get the information only and missed filing of the same. I really regret the same and assure you not to repeat in future in view of the above sense. The authorities are helpless because, my lord, of the last deed, but the extenuating circumstances, my lord. And here, my lord, the reservation is made with a reason, my lord. The reason is, my lord, to facilitate children of the defense forces. And here, my lord, there is a case where none of the 12 seats, 9 and 3, would be filled up from the defense quota because there is no candidate at all. So no one will be affected, my lord, if the petitioner is permitted to be allowed to participate in the counseling and her candidate. And she has a very high score, my lord, 82 percentile, my lord, in the NE. Her all India rank, my lord, is all India rank is 378382, and in the general category is 115166. My lord, her NET scorecard I have annexed at page 36.
You have said that she's the only applicant
My lord.
for this category.
My
But your prayer interim says that you keep at least one seat vacant.
One seat vacant.
If there's nobody else, then where's the question of keeping a seat vacant?
Because if
You have all the 12 seats vacant.
My lord, if the seat is not filled up from the defense quota, my lord,
It'll go to the other category.
And the counseling will start from tomorrow.
What is the nature of the counseling?
That's admission. They say it's counseling.
No, I
but
mean like
selection of colleges.
it is for a particular period of time or it's just a one-day affair?
But it starts from tomorrow and it will continue, my lord. The notice, there is a notice, my lord. Dated. It's page 79, my lord, the schedule is given. The first round of counseling, if my lord comes to page 79, serial number 1, 24th July to 29th July.
Page number?
Page 79, my lord.
79.
That's the first round of counseling. The candidates who are top of the merit list, they are called, my lord, and the medical colleges are assigned to them. That is the counseling. It's basically admission, selection of the medical colleges. The authorities said that their hands are tied. They wanted to help us. That's what they said, but their hands are tied because of the
Last date.
Last date. And they accepted it's a genuine case. But my lord, because of that date, they.
Mr. Bora?
My lord, considering it the special case because from the defense personnel, my lord, and since he was engaged in a particular operation since 16/7. So as an interim measure, she may be allowed, we may allow her to, we may accept her application provisionally and she may take part in the counseling process, my lord. Her application may be accepted, my lord.
All right. Please write. I heard Mr. Pedina, learned counsel for the
And your
petition.
lordship may indicate that as a special case because her father was involved in a special operation.
Pedina, learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to consider our candidature for admission to the first year MBBS/BDS courses in government medical and dental colleges in the state of Assam for the session 2025 under the special quota for children of serving defense personnel. Stop. The learned counsel submits that the petitioner has good academic records and she had qualified in the national eligibility cum entrance test conducted for the purpose. But however, she could not submit her application during the within the stipulated time, that is 11th of July 2025. Which was for a bona fide and genuine reason. Stop the learned counsel submits that the father of the petitioner is serving as a group captain under the Indian Air Force, and he has been involved in a recent operations of national security which did not allow him to be relieved till 16th of July 2025. Stop. The father of the petitioner, no, cancel that. The petitioner could only secure a certificate that was required from the commanding officer, under which the father of the petitioner was serving, only after he was relieved on 17th of July 2025. Stop. Hence the delay in submission of the application. Stop. The learned counsel submits that under the special category meant for the children of the serving armed forces or ex-servicemen, there are 12 seats reserved. And to the knowledge of the petitioner, there are no applicants except for the petitioner. Stop. The petitioner, through her father, had submitted a representation to the Director of Department of Medical Education, Government of Assam, on 18/7/2025 for considering her application, but the same could not be considered. And therefore, the petition is before this court. Stop. Next para. Issue notice of motion returnable by 3 weeks. Mr. D.P. Bora, Learned Standing Counsel, Health Department, accepts notice on behalf of
All the respondents.
all the respondents, and therefore no formal notice is called for. Full stop. Petitioner shall, however, furnish requisite copies of the writ petition to the Learned Standing Counsel within 2 days. Next para. Having regard to the projection made by the petitioner, and at the same time keeping in view the reasons for the delay, court is of the considered view that as a special case, the application of the petitioner be accepted by the respondents and she be allowed to participate in the counseling process, which is due to start from 24th of July 2025. Stop. List the case again after 3 weeks.
They may need to revise the merit list as well. If my application is accepted.
My lord, if it is accepted, all the consequences.
It is
will be
needless to
done.
mention herein that in view of the permission granted by this court, the respondents may do the needful for revision of the merit list in accordance with the procedure. All right.
The next date of listing to be listed, my lord.
3 weeks.
3 weeks, my lord. Deeply offensive.
Oh. So we'll reassemble at 2 p.m.
75.
May it please.
Yes.
My lord, we are employees of Gwalpara Polytechnic, my lord.
Hmm.
My lord, what has happened? May I kindly give a background of the case, my lord?
Surely.
There is a connected matter as well. That is. My lord, what had happened is that, my lord, what OM was issued by the Commissioner and Secretary Higher Education Technical Department, my lord. If my lord has the OM at page 36, my lord. My lord, this OM 13/9/24, my lord. My lord, here, my lord, regarding all the other polytechnic colleges, my lord, of Assam, my lord, certain conditions were laid for appointment of grade 4 employees. We are also grade 4 employees. My lord would have the criteria at this page only, my lord. Point number 2, my lord. If I may kindly read, my lord. Point number 2. Born in Assam and be from respective district where the institution is located, having initial education in the state. Discipline, medically, physically fit enough to carry out the specified job in the organization. Above 18 years and not more than 40 years of age. Minimum class 8 pass. And my lord, the number of posts, my lord, that is at point 1, my lord, the above point. The governing body of the engineering colleges / polytechnics will be authorized to engage 17 grade 4 staff on temporary basis. So my lord, the number of posts that was earmarked was 17, my lord, as per the OM. Now what had happened is that, my lord, the colleagues of the instant petitioner, some of the colleagues, they had challenged this OM, my lord, by preferring a writ petition, that is 7001 of 24. I have annexed the interim order which they had obtained from this honorable court. My lord will have the said interim order at page 38 onwards, my lord. And the effective page is at page 5050, my lord. It begins and 50 is the relevant page. May I read my lord?
You are aggrieved by this office memorandum?
No, my lord. We are aggrieved by this order. Now,
Which
my
order?
lord,
Which order?
This order which I'm referring to, page 38, my lord. The order passed in one of the writ petitions, my lord. My lord,
38.
on the strength 38. The OM backs us, my lord. We fit into the age criteria, my lord. 18 to 40. We are all under 40. Whereas our colleagues, my lord, who have obtained the stay, my lord, their services are protected. They have all crossed the age of 40, my lord. My lord, may kindly have page 38 and 50 is the relevant page, my lord, of the order. 50. May I read my
In what way you're aggrieved by this order?
My lord, we are aggrieved, my lord, because this order says that the OM is not to be given consideration, my lord. The relevant portion is having regard to the projections made on behalf of the petitioners and considering the fact that petitioners are currently engaged in the concerned polytechnic since last 7 years continuously, respondent authorities shall not replace the petitioners by taking resort to the OM dated 13/9/24. That was the interim order passed by this honorable court. Now, my lord, what has happened is that the services of of our colleagues have been protected by this order. Now, my lord, the authorities, my lord, they had come up with minutes of the meeting, my lord, regarding appointments, my lord. If my lord has page 80 for a moment, annexure 8, this is regarding new appointments, my lord, in lieu of the said OM, my lord, page 80. My lord, minutes of the meeting held on 22nd January 25. Here, my lord, regarding different institutions, my lord, page 81, my lord would find our institution, my lord. Page 81, column number 7, my lord. Gwalpara Polytechnic. Gwalpara Polytechnic, examination not held. The principal of Gwalpara Polytechnic stated that they have not started the process for engagement of grade 4 employees and is waiting for the High Court verdict. My lord, this High Court verdict is the case, my lord, that 7001 of 24, which I had just referred to, my lord, that protection, my lord. Thereafter, my lord, the said college authorities, they come up with one impugn notice, my lord, conducting examinations for the grade 4 employees. That, my lord, would kindly have at page 83 for a moment, my lord. 83, my lord. This is why we are aggrieved, my lord. This is the entire case, my lord. 83. May I read, my lord?
Yes.
As per direction of Director of Technical Education, Assam, fresh applications are invited for the following wage-based temporary posts for the working attendant staff of Gwalpara Polytechnic, having experienced more than 5 years. The age must be less than 40 years as on 1/1/24. The engagement will be purely temporary wage basis for a period of 11 months as per government OM. You will have to appear in a written test followed by an interview for selection of 9 numbers of post of grade 4 staff. These are the posts, my lord. In the next column, attendance 6 numbers, security guard 2, and cleaner sweeper 1 post. So, my lord, total 9 posts. Whereas in the OM, my lord, which I referred to initially, 17 posts were earmarked. That means, my lord, these persons, my lord, who had obtained the stay, my lord, that is the private respondents number 5 to 11. They are being exempted from this, my lord. And the minutes of the meeting also reflect the same, my lord, that they are getting a blanket protection in lieu of their interim order. Now, my lord.
An order was passed in this regard.
Yes,
Another
my lord,
case.
similar orders. Yes.
Where is that?
My lord would kindly have page 84, it starts. 88 and 89 is the effective portion. It is in fact my lord's order only.
IA. This was passed in IA.
In the IA, my lord, in the IA, because there the persons were impleaded. Here we were not impleaded. That is why here we didn't come for impleadment. That is why we have filed a fresh writ petition. But similar cause, my lord.
And the process is to start when?
My lord, end of this week. In the notice, it is stated at the end of July. So, my lord, from tomorrow, any day, my lord.
So what kind of order are you seeking now?
My lord, similar orders, protection of our services. We want to participate in the examination since it is a mandate. But, my lord, some protection because, my lord, already they have reduced the post. From 17, they have made it 9. So, it's not a fair game, my lord. So, that much protection, similar order if it pleases, my lord.
Yes.
Page 88, 89.
Who is there for the other side? Orders have been passed earlier.
Yes. Maluk, there is similar order, Maluk, that will be passed. Page 92.
92 does the orders. 88, 89, and it does.
It's a grade 4 post, isn't it?
Yes, ma'am.
You are Mr. Sharma?
Yes, my lord.
PR,
Yes, my lord.
not Mr. PR Sharma, learned counsel for the petitioners. Who submits that by filing this writ petition, the petitioner has challenged the notice dated 15/7/2025, by which examinations are set to be conducted only for 9 grade 4 posts in Golpara Polytechnic College. In violation of the office memorandum dated 30/9/2024, wherein it is provided that there are 17 numbers of posts. The learned counsel submits that in a case of similar nature, this court had given the protection to the effect that the similarly situated persons, like the present petitioners, would be at liberty to participate in the selection process pursuant to the said notice, but however, without prejudice to their rights to participate for the entire 17 numbers of posts of grade 4. So further, it was also provided that their services should not be disturbed pending final decision of the court. So the learned counsel submits that since the petitioners are also similarly situated, and a similar protection may be given to them. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. Yes, learned counsel. You are Mr.
S. Das.
Mr. S. Das,
Standing council higher education.
learned standing counsel, higher education department.
And we are paying for 1, 2, 3, and 4 months.
Accepts notice on behalf of respondent numbers 1, 2, and 4.
1, 2, 3, and 4 months.
1, 2, 3, and 4. Anybody else?
Others, notice will.
Others, my lord, private respondents, my lord. Notice may kindly be.
You're appearing for the Golpara Polytechnic also.
Yes, yes. The government polytechnic.
Petitioners to serve requisite copies of the writ petition to Mr. Das within 2 days. Stop petitioners to take steps for service of notice upon the remaining respondents by registered post with AD due within 3 days. But it is further provided that the petitioners would be at liberty to participate in the selection process in terms of the notice dated 31/5/2025.
No, my lord, 15/7/2020.
Where's the date?
My lord, page 83, my lord. 83, my lord, has for a moment.
The dates are different.
No, dates are different, my lord. These are different, but similar in nature.
Okay. Earlier I'd given you a date, man.
My lord, date is page.
It's okay.
83. Sorry.
In terms of the notice dated 15/7/2025, without prejudice to their rights to participate for the entire 17 posts of grade 4. Stop, it is also provided that pending final disposal of the final decision from this court, the services of the petitioner should not be disturbed. List again after 4 weeks.
I'm deeply obliged, my lord.
Time being 72.
Yes.
My lord, hearing this case, my lord, by filing an application, we have brought my lord for rechecking of my answer script, my lord. My lord, only my lord, English paper, my lord, in which my lord, I have given only 72 marks.
Where is your application?
My lord, application, my lord, page 50, my lord, annexer
Page
6.
50.
Page 50.
50. When was it filed?
My lord, it was filed, my lord,
In May.
26/5/2025. My lord, what happened, my lord? May my lord explain, my lord? My lord, on our application filed by the petitioner, my lord, we have been supplied the answer script. After going through the answer script, it is found that some questions are very much correct in grammatical, my lord. There is no word mistake. There is no wrong, my lord. My lord, every question has cut down, my lord.
This is for the matriculation.
Matriculation. My
Okay.
lord.
Is
My
there
lord,
any provision for rechecking?
My lord, that's why, my lord, in earlier
Reevaluation.
your lordship was pleased to ask, my lord. That provision, my lord, my lord, my lord.
Yes, my lord, there is a provision for rechecking. Rechecking does not mean, my lord, to, if it is, my lord, evaluated, my lord. If it is, if the answer, subsequent answer says evaluated, my lord, then there is no scope for re-evaluate, my lord. As per our provision, my lord. My lord, this matter may be, my lord, notice may issue, my lord, will obtain instruction and file affidavit, my lord.
My lord, only other thing, my lord, one point may I point out, my lord. In my lord, our my lord grievance in descriptive types of question marks 45, my lord. My lord, here in descriptive part, my lord, I have got 21. But in my mark sheet, 23 mark has been given, 2 mark more given, my lord. My lord, I do not understand what type of examiner has, my lord, calculated the mark and what mark has been put it in the mark sheet, my lord. Put in the mark sheet, my lord.
How much you got in the paper?
My lord.
How much marks did you get?
My lord, 72 marks, my lord.
72.
My lord, in other subject, you lordship kindly see in Assamese subject, my lord, I have got 93 marks. General mathematics, 96
No,
marks.
no. That's not what I'm asking you. You are saying that the marks which has been, the marks has been wrongly evaluated.
My lord,
In your paper, answer script, how much did you get?
my lord, correct question cut down.
No, how much marks was given to you in the answer script?
My lord, in my lord, 45 marks, my lord. My lord, what happened, my lord? In English paper, there are some parts, my lord. Objective type of question, 45 marks. Descriptive type of question, 40 marks, 5 marks. And my lord, internal assessment, 10 marks. Total, my lord, 100 marks. And my lord, I am awarded with 72 marks, my lord. My lord, beyond my imagination, my lord. And in comparison of other subject, my lord, very poor mark. In fact, my lord, I have distinction mark. I have got, my lord.
So this pertains only to English paper.
English, my lord, only English.
Okay, will issue notice. Mister.
My lord, my submission, my lord, my answer script should be re-examined by another expert, my lord.
Not immediately. We'll have to examine. Mr. A. Manaf,
A. Manaf.
learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent Assam State School Education Board, bracket, the board, close bracket, to recheck and reevaluate the petitioner's English answer script, particularly in relation in respect of descriptive question part section B, C, D, and E. in relation to the examination for HSLC
Yes.
that the petitioner undertook. Stop. The learned counsel submits that not being satisfied with the marks, the petitioner sought for the answer scripts, which was provided to the petitioner. So upon perusing the answer script, the petitioner found that the petitioner has not been allotted marks in respect of
Question number
question numbers
48,
48, 49, 50, 53, 57, 58, 59, 60, 62, bracket Roman 1 small, and 63, bracket small Roman 2.
Yes. Yes.
Stop. Although the petitioner submitted an application for re-evaluation on 26/5/2025, but since the same has not been considered, petition is before this court. Next para, in view of our issue notice of motion returnable by 4 weeks. Mr.
DK Roy.
DK Roy, Learned Standing Counsel, ASEEB, is it?
Yes, ma'am.
Accepts notice on behalf of
2,
the
3 and 4.
respondent numbers 2, 3, and 4. While school education, who's there? No one. B. Kaushik, Learned Standing Counsel, School Education Department, accepts notice on behalf of respondent number 1. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing for the respondents today within 2 days. List the matter again after 4 weeks.
If that may be given, my lord. Otherwise, my lord, he is a student, my lord. My lord, he is suffering from a mental anxiety, my lord. A fixed date may be given, my lord. After 4 weeks, my lord.
2 weeks, nothing will happen in 2 weeks. You'll need some time, you see.
Yes, ma'am.
List the matter again after 4 weeks on a date to be fixed by the registry.
Obligation.
Time being 22 and 23.
Right, my lord. My lord, the petitioner is serving as assistant teacher in Sri Sri Shankardev Higher Secondary School, Nagaon, my lord. He has been deprived of, my lord, holding the charge of principal, in spite of he is the senior most eligible and qualified teacher. Seniority list is at page number 41, my lord. The lordship will find the name of the petitioner at serial number 1 at page 41. Dipankar Giri, Deb Goswami. And my lord, he is getting the graduate scale of pay with effect from 30/12/1993. It is given at column number 7. And he is having MA and BEd degree, my lord. And on the other hand, my lord, at serial number 3, private respondent who has been allowed to hold the charge has been getting the graduate scale of pay with effect from 22/10/1998. Okay, lordship got it.
You are aggrieved by Annexure 7.
Yes, lordship. It is
Who is
issued
he? Respondent number?
Respondent number 4, serial number 3 at page 41, my lord.
Dhiramoni,
Yes,
respondent number 4.
respondent number 4, my lord.
So this is in dispute, isn't it?
Yes, sir.
Who is more qualified, who's more qualified to be in charge principal?
As per seniority list, my lord, I am the
Senior
senior most.
and pay scale?
And I'm having the master degree and B.Ed, my lord. And I'm getting the graduate scale of pay with effect from 1993, my lord. And that's why, as per Rule 12, I am the senior most eligible qualified.
To be in charge?
Yes.
Rule 12 of?
Rule 12 of, my lord, 2018 service rule, my lord.
What is the full form?
Wait a second. Assam Secondary Education Provincial Head Schools Rules 2018.
Will issue notice?
This means implement may be suspended, my lord.
Order was passed already on 4/7.
During the vacation, summer vacation, it is passed, my lord.
But what to do? Will issue notice only.
And my lord, earlier round of litigation that is also pending, fixed on 6th, my lord, fixed 6th of August, my lord, WPC number 3407 2025. In that writ petition, my lord, the petitioner has challenged the annexure 6.
Same petitioner.
Same petitioner.
What is annexure 6?
Annexure 6, my lord, whereby the inspector of schools was given the charge of the
Okay.
principal.
Then the other writ petitioner has become infructuous.
Yes. In that case, my lord, it is given in observations made, not issues on interim clearance.
But in view of this annexure 7, it has become infructuous. Heard Mr. B. Prokasta, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 4/7/2025, bracket annexure 7, by which the private respondent number 4 has been allowed to act as principal in charge of Bata Darava Sri Shankar Dev Higher Secondary School in the district of Nagaon. By relieving the inspector of schools, Nagaon, from the charge. The learned counsel submits that the petitioner is senior to respondent number 4 and has also received the graduate scale earlier to the private respondent number 4. Therefore, the petitioner is eligible to be made the in-charge principal of the school in terms of Rule 12 of the Assam Secondary Education Provincialization Rules.
Provincialized schools in bracket.
Provincialization within bracket schools.
Provincialized schools.
Provincialized schools.
Within bracket.
Assam Secondary Education within bracket Provincialized Schools Rules, 2018. Stop next para. In view of above, issue notice of motion returnable by 4 weeks.
I'm appearing for response 1, 2, and 3.
Learned Sending Council, School Education, but accepts notice on behalf of respondent numbers 2 and 3.
1, 2, and 3.
1, 2, and 3.
4 notice maybe.
By the service, you should take out.
Stop petitioner to serve requisite copies of the petition to Mr. B. Kaushik within 2 days. Stop petitioner to take steps for service of notice upon respondent number 4 by registered post with ADU within 3 days.
As well as by Dasti, my lord.
Stop. In addition, The petitioner is allowed to serve notice to respondent number 4 by way of Dusty through the registry of this court and thereafter file an affidavit as proof of service. Also issue notice on the interim player, returnable by 4 weeks. List the matter again after 4 weeks on a date to be fixed by the registry.
But it may come along with WPC number 3407/2025.
List the matter again after 4 weeks. After you add with WPC number
3407/2025.
3407 of 2025.
23.
May I please? In this case, my lord, the petitioner has applied for the post of graduate teacher, my lord, pursuant to advertisement, Annex 4, my lord, page 20. TETCOM recruitment, my lord, scheme. And she has been allowed to appear in the TET examination. And my lord, thereafter she has been asked to appear before the selection board for verification of documents by Annexer 7, page 31, my lord, on 1/7/2025. On the day when, my lord, she has appeared before the selection board, my lord, she has produced her certificates of sports, Annexer 2C, my lord, national level certificate, Annexer 2C, page 18, whereby she has participated, my lord, in the National Karate Championship. The certificate has been produced, my lord. What they have said, my lord, they asked for the letter issued by the sports authority whereby she has been invited to for participating in the sports, my lord. That letter is not with her, my lord. If they have any doubt or with regard to the genuineness of the certificate, it is the procedure, it is the duty of the, my lord, employer or the appointing authority, my lord, to seek clarification from the certificate issuing board, my lord, certificate authority, my lord. Instead of doing so, my lord, her candidature has been withheld by the impugned remarks, page 32, my lord. It is given in the backside of the application. Kept in hold due to non-submission of official letter from the competent authority. It is an absurd idea, my lord. If I am supposed to produce my certificate, whether the prospectus of the university under which I got the admission, that is not required to be submitted. It's like that only. They have asked for the letter whereby I was invited to the competition. Who keeps this such types of letter, my lord? Generally, the certificate is the final document, my lord. If the authority has any doubt over the certificate with regard to genuineness, it is open to them, my lord, to inquire with the certificate issuing authority.
Which is the certificate?
Certificate Annexer 2C, my lord, page 18. National Karate Championship, 7th ISKF. ISKF is the authority who regulates, my lord, Karate Championship throughout the nation.
This is for considering your
candidature for the post of graduate teacher. If this certificate is taken into consideration, I get another marks, my lord, for in the selection process.
How many posts are there?
Posts, my lord, numbers of posts are there, but the question is the process is going on and my candidature is withheld for no fault of mine.
How long is the process going on?
Process, they have submitted all the districts will submit the my lord, after verification to the director level, and now it is online generated system. It is conducted by the SEBA, is regulating the online system, my lord, and after that the merit list will be published.
Yes, Mr. Kaushik.
No, let this matter come up next week, I'll obtain instruction.
And if they in the meantime, my lord,
I don't think so, my lord, because the provisional select list is yet to be published.
Art Mr. B. D. Prokashta.
That is remain on motion, my lord, in that case.
Yes, yes.
Learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the
Impugned endorsement.
action on the part of the Inspector of Schools, Nagaon, keeping on hold the candidature of the petitioner for the post of graduate teacher in respect of Nagaon district. Solely on the ground that the petitioner has failed to produce the invitation given to her for participating in the 7th ISKF National Karate Championship. To stop, the learned counsel submits that, in fact, the petitioner has furnished the certificate issued in this regard, but despite the same, the respondent authority concerned has kept her a candidature on hold. Stop next para. Considering the above stand, Mr. B. Kaushik, learned standing counsel, Higher Education Department,
Respond number 1, 2, and 4, my lord.
shall obtain instructions by the next date. Petitioner shall serve one extra copy of the writ petition to Mr. B. Kaushik to enable him obtain instructions. List the matter again on so and so.
28, my lord. Right.
Item 25 for Impleadment.
My lord, this I have been filed for implement of the new incumbent, my lord. Mrs. Pumi Borua as Director of Higher Education, my lord, as respondent number 6 in place of respondent number 2, my lord. And we have served a notice to her also, my lord, on 17/6/2025 at page 7.
Whom do you want to implead?
My lord, in place of my lord, respondent number 2, Mr. Noyan Kumar Pathak, Director of Higher Education, my lord. Now he is not holding the post, my lord. Now new incumbent Mrs. Pomi Borua joined, my lord, as a Director of Higher Education, as respondent number 6 to be included.
I heard Mr. D.K. Roy, learned counsel for the. Any objection?
No, lordship. Anyway, lordship, it's a contempt petition, lordship, so the notice will have to go, lordship.
No, we are allowing the impleadment. I heard Mr. D.K. Roy, learned counsel for the applicant who submits that by filing this application, the applicant seeks impleadment of Mrs. Pomi Barua, Director of Secondary Education, Assam, as respondent number 6 in the.
The Director of Higher Education.
Then make the correct prayer. You come up with such mistakes and you tell me something else.
I apologize, my lord. It should be higher education.
Mrs. Pomi Barua, Director of Higher Education, as respondent number 6 in the connected contempt petition. since she is the new incumbent holding the said post. Most of the learned counsel submits that Impleadment is necessary for effective compliance of this court's direction. Next para, it is however seen that the petitioner has, no, the applicant has written, has given the designation of the respondent number, given the designation of the respondent sought to be impleaded as Director of Secondary Education. Stop. Since the learned counsel submits that the same is due to some typographical mistake, and in fact, the respondent to be impleaded is a Director of Higher Education. Comma, the same is accepted for the ends of justice. Full stop. In view of above, Impleadment application for impleading Mrs. Omi Barua, Director of Higher Education, Assam, is hereby allowed. IS stands disposed of. And in the main, in view of the order passed today in IAC number 2238 of 2025, Srimati Omi Barua, Director of Higher Education, Assam, is hereby impleaded as respondent number 6. Stop. Petitioner to file the amended cost title in 2 sets before the registry within 3 days, whereafter the registry shall do the needful. Next para, issue notice to the newly impleaded respondent number 6, returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent number 6 by registered post with AD due within 1 week. List again after 4 weeks on a date to be fixed by the registry.
Matters for orders, item 56.
Yes.
But I am appearing on behalf of my lord, respondent number 3 and 4, my lord.
Yes. What is the instruction?
My instruction, my lord, now my lord, department wants to file a review, my lord.
They have filed?
No, my lord, they have instructed us to file a review, my lord.
Which is the order not complied with?
Order is at page 14, my lord. 1-4. There was a direction to pay the arrears salary from August 2007, my lord.
This is a typed copy of what?
This is a type copy of the order, my lord.
Where is the original copy?
Original, my lord. I think they have not annexed the original one.
Then what is the date?
In fact, in my copy, my lord, only the type copy is available.
Date of the order?
My lord, date of the order, my lord, will find.
It's not available.
It's 7/2/2017.
That is there in page 17.
Yes, madam. 7/2/2017.
Is it the same thing as page 14? You are representing which respondent?
Respondent number 3 and 4, my lord.
Who are they?
Well, 3 is the secretary, my lord, and 4 is the director of elementary education.
Narayan Konwar.
Narayan Kumar, my lord.
Narayan Konwar and
Suranjana Senapati.
okay. They are currently holding the post.
Narayan Kaur is holding the post of secretary, and Suranjana Senapati, she is holding the post of director of elementary education.
So this order was passed way back in 2017.
Yes, my lord.
So why it has not been complied with?
My lord, in fact, there is subsequent development.
Like what?
Because this petitioner, she was identified as illegal and irregular teacher of Dhemaji district, my lord. Those teacher of Dhemaji district, my lord, they have participated in a screening process. Pursuant to the order of this honorable court, my lord, a screening committee was constituted. They have participated in that process, and subsequently she has been accommodated as tutor, my lord. Being an illegal appointee, my lord, cabinet took a decision. Those who are working, they have been accommodated as teacher or tutor according to their qualification.
Then?
So that is why, my lord.
So what is the direction to accommodate?
Direction was to pay the salary, my lord.
As tutor?
No, my lord. As teacher. Salary was stopped in the year 2007.
So you do not prefer an appeal?
No, in fact, my lord, there are some similarly situated persons. They have filed a writ petition. That writ petition was allowed, my lord. A batch of writ petition was allowed. State has preferred appeal, my lord. That appeal was dismissed. And on the basis of that dismissal order, my lord, this writ petition was allowed, my lord. And this petitioner, in the year 2012, she participated in the screening process. And the screening process was completed in the year 2000, finally in the year 2020, my lord. And from October 2020, those who had been working till the date of cabinet decision, they have been accommodated as teacher or tutor according to their qualifications. And this petitioner, she was also given the fresh appointment, madam. So that is why, madam, now government.
So that fresh appointment and all that, it happened after the disposal?
Yes, madam.
Of the writ petition?
Yes, madam. Disposal of the writ petition. The petition was disposed of in the year 2017, and screening process was completed in the year 2018, but decision was taken in the year 2020, madam.
But was there any liberty given to you to change the nature and character of the appointment?
No, madam. There is
then on your own you have taken such
no, madam.
decision.
This petitioner, and in the screening process, it has been found that they are appointed illegally. There is no record of their appointment.
Who has directed you to make the screening?
In the year 2010, my lord, there is a direction from this honorable court to take a concrete decision as regards the appointment made during the year 1989 to 2001.
No, we are concerned with the writ petition only in this case.
Yes. So, since this petitioner, she has also participated in the screening process. So, her case was also considered according to the decision taken in the cabinet, madam. And it has been found that she was appointed illegally, but she was continuing. So finally, cabinet took a decision to those persons who are though appointed illegally or irregularly, but they are continuing to accommodate them as tutor or teacher according to their qualification.
Anyway, we are concerned with the compliance or
Yes, my
otherwise
lord.
of this
Yes, my
order.
lord. Regarding compliance, my lord, now, my lord, we have been instructed to file a review stating this fact, my lord, since she participated in the screening process, my lord, and she was identified as.
But is that possible to be done at this stage now?
My lord,
Disposal was of 2017.
yes, that I understand, my lord. Well, let us make a try, my lord. Maybe if we can convince your lordship.
No, it's not that you have filed the review. It's that you have been asked to file the review.
Yes, my lord.
So why should we not call these persons and ask them why they should not be punished for sitting over the matter?
Well, give me one chance so that
That is the issue. You see, whatever justification you give,
yes, my lord.
action you take is something else. If you had wanted to do that, you should have sought for a review there and then or for an appeal. You have not done that. Now, it's almost 8 years now.
Yes, my lord.
More than 8 years now. Please write down none appears for the petitioner when the matter is called. Mr. N.J. Katania. Learned Counsel appears for the respondent numbers 3 and 4. And submits that he has been instructed by the respondents to file a review petition against the order dated 7/2/2017. Passed in WPC number 680 of 2016. Full stop. It may be seen that despite the fact that the order not being complied with by the respondents was passed on 7/2/2017. The respondents, instead of complying with the same, has instructed their counsel to file a review petition. Full stop. In the absence of any stay of the same or the review petition being already filed, this court is not inclined to accept such a submission. Stop under this circumstance. The matter be listed again after 2 weeks on a date to be fixed by the registry.
Obliged.
57 and 58.
My pleasure, Lordship. So in this case, the petitioner number 1 has filed one IA for striking out his name, Lordship. Petitioner number 1, the IA number 1970. His name may be strike out, Lordship.
Who has filed this? Petition number 1. In which case? 7922. What about 6800?
6800, the petitioner wants to withdraw this case.
Wants to withdraw.
Yes, sir.
So what will remain now then?
In-
7992 will remain
Yes, sir.
without petitioner number 1. How many petitioners are there?
There are initially 4 petitioner, Lordship, but petitioner number 3 was already struck off. Now the petitioner number 1 is before your Lordship for striking out his name. And Lordship, petitioner number 4 also today instructed us to strike out his name, Lordship, to make a prayer before your Lordship to striking out his name. Petitioner number 4 also. So only one petitioner will remain, that is petitioner number 2.
What happened to petition number 1?
Petitioner number one, Lordship, now he is not interested to pursue the case.
Already struck off?
Mm.
Or now only, today?
Petitioner number.
3 was already struck off.
Already struck. Now Lordship 4 was also instructed us to make a prayer before Lordship to striking out his name also. So 1 and 4 maybe strike out Lordship.
But we have not made a prayer like that in the IA, isn't it?
Not been filed.
So, what is your good name?
P. Soria.
Heard Miss P. Saharia, learned counsel for the applicant. Is IA 1970, okay? 1970/25. Heard Miss P. Saharia, learned counsel for the applicant who submits that by filing this application, the applicant who is the petitioner number 1 in WPC number 7992 of 2022 seeks striking of his name from the arrayed petitioner. Full stop. She further submits that although the application does not say so, but the petition number 4, is it? 4 also wishes to strike off his name from the arrayed petitioners. Yes, madam, other side.
Your Lordship, as per the last order,
Ah.
we were directed to bring in after verification, to bring in the report, Your Lordship, to get the report regarding the disability. We've received our report, Your Lordship. We'd like to bring
No,
it on.
I'm asking you about the application. Any objection?
No, no.
Miss, your good name?
RM Borwa on behalf of Mr. A. Chaliha.
Miss R.M. Barua, learned counsel appearing on behalf of Mr. A. Chaliha.
For Health Department, Your Lordship, for respondent 5, 6, and 7.
Standing Counsel, Health Department, submits that she has no objection to the prayer. Full stop. In view of above, the name of petition number 1 and petition number 4 be struck off from the arrayed petitioners as prayed for. Stop. IA stands disposed of. Full stop. Then in the WPC number, just a minute, 7992. You write like this, 7992, okay, read petition. In view of the order passed today in IAC number 1970 of 2025, the name of petition number 1 and petition number 2 is hereby allowed to be struck off from the arrayed petitioners. Full stop. Petitioner to no, stop. It is also seen that the name of petitioner number 3 has already been struck off, and therefore only petition number 2 remains. Full stop. Petitioner shall submit the amended cost title in 2 sets before the registry of this court, whereafter registry shall do the needful. Anything to be said in this 7992?
So Lordship, and regards that, we have received our report, Your Lordship, and
Yes.
to bring it on record, Your Lordship.
Miss RM Deka,
RM Borwa, Your Lordship.
so RM Borua, learned
Appearing on behalf of Mr. A. Chaliha for the Health Department, Your Lordship.
counsel appearing on behalf of Mr. A. Chaliha, Standing Counsel, Health Department, submits that she may be given how much time?
2 weeks' time, Your
2
Lordship.
weeks' time to file an additional affidavit to bring on record the instructions she has received. Prayers allowed. List again after 2 weeks on a date to be fixed by the registry. In the meantime, full stop. In the meantime, let the additional affidavit be filed. Then what orders can be passed in the other?
Application number 6800, the petitioner wants to withdraw this case also.
Item 58, you write, as paid for by Miss
Sorry.
P. Sorani, learned counsel for the petitioner on instructions. The writ petition stands disposed of as withdrawn. Stop. Miss R.M. Borua, learned counsel, appears on behalf of Mr. A. Chaliha, standing counsel, Health Department. You're also there? Stop, Mr. S. Das, learned standing counsel, Higher Education Department, also appears on behalf of the Higher Education Department.
Public. 59.
As per the instruction sought for by the Honorable Court, with regard to status report for creation of the post. For 130 post of principal and vice principal, for creation of the post, for concurrence, it has already been forwarded to the finance department. And for 810 posts, it's ready to be endorsed to the finance department. We will require some more time for the
This will include the post for the present school.
এটা পেৰেণ্টছটো পঠালে এটা পঠাবৰ কাৰণে 132 ডেটটো দিয়া নাই অলৰেডি বিন ফৰৱাৰ্ডেড মই এটা অলমোষ্ট গোটেইখিনিৰ ভিতৰত এটা কোনটো মানে হেৰি পোষ্ট এটা ক্ৰিয়েট হৈ গৈছে
Yes.
Let this come after 3 weeks, in the meantime.
Parties are represented by the respective councils. At the outset, Mr. B. Kaushik.
Secondary.
Learned Standing Council, Secondary Education Department submits that the proposal for creation of 130 posts of principal and vice principal has already been forwarded to the finance department for necessary concurrence. Stop. Additionally, the proposal for creation of 810 posts of principal
405
and 405. No.
But the 810 includes this 405 and 405 vice principal.
Okay.
Total is 810.
What did I say? Additionally? 810 posts, open bracket, 405 post of principal and 405 post of vice principal, close bracket. is ready to be endorsed to the Finance Department for consideration. The learned counsel submits that he has received such an instruction from the Secretary to the Government of Assam, Department of School Education, by his letter dated 17/7/2025. Next para in view of above. Let this matter be posted again after 3 weeks on a date to be fixed by the registry. Mr. B. Kaushik shall inform the up-to-date status of the said proposal by the next date. Top a copy of the communication dated 17/7/2025 produced by Mr. B. Kaushik shall be retained on record and marked as X for amplification.
Item 60.
Complied.
The order is compliant.
Yes, Mr. Counsel.
Yes, already rejected.
We'll have to take some other steps.
Yes.
Mr. You're Mr. Chauhan?
Yes.
Heard Mr. R.S. Chauhan, learned counsel for the petitioner, and Mr. B. Kaushik, learned counsel for the respondent. At the outset, Mr. B. Kaushik has produced order dated 14/9/2023, passed by the Director, Secondary Education, and submits that the order of this court dated 10/6/2022, passed in WPC number 5670 of 2017, has been complied with. Stop. A copy of the said order learned counsel for the petitioner, who also acknowledges the submission. In view of above, the contempt petition stands closed. Have a copy of the order dated 14/9/2023, made by the Director of Secondary Education, produced by Mr. B. Kaushik, shall be retained in the record and marked as X for amplification.
61.
Why did I say this is closed? Closed.
61 is also compliant.
Which is the order to be complied with?
The
14/6/23.
Yes. Direction was to consider and dispose the representation.
None appears for the petitioner when the matter is called. Mr. B. Kaushik, Learned Counsel, appearing for the respondent by producing order dated 2011-2023, passed by the Director of Secondary Education, submits that the order dated 14/6/2023, passed by this court in WPC number 6329 of 2022, has been complied with. To stop in support of his submission, the Learned Counsel has produced a copy of the said order. To stop in view of above, the contempt petition stands closed. A copy of the order dated to 2011-2023, produced by Mr. B. Kaushik, shall be retained in the record and marked as X for identification.
62 and 63.
Before the finance department for examination, some financial implication is there, so finance department has to examine the matter,
Your application also, my lord, similar submission was made.
Here, they are paying old pension,
How much time should we require?
This is before finance department, they will respondent number 2 is the appropriate authority to reply the same. He is the respondent 2, finance department secretary. No? Finance department, respondent 2 is the finance department.
You are for which respondent?
I am for 3, in item number 62. Here, secretary has forwarded to the finance department.
Anyone appearing for 2? Any appointed counsel?
Last application, my lord. Yeah.
No one has appeared for 2 so far.
Last
What about notice? Notice is complete or not?
Yes, sir. Last occasion, my lord, appeared.
But there's no such kind of record that somebody appeared in the order sheet. All that says 3.
Very far. It 2 whole, 1 whole is direct. We have 3 whole direct. Okay. I think this is our it is from one secretary, 3 whole direct. 2. It is equal to 2. Notice, sir.
Who is respondent number 2?
Finance, my lord, notice
Huh?
served already.
Name. It's by name, isn't it?
My lord.
What is the name? Samir Sinha.
My lord.
So how is he served?
Registered post, my lord.
When? By which order?
First order, my lord, when the notice was issued.
Oh, first order notice will go, but acknowledgement.
Secretary, commissioner. May I please, your lordship? Your lordship, the respondent number 2 is no longer holding the post, your lordship. The present contender has to be impleaded, your lordship. The present contender is Jayant Nalikar, your lordship, Commission Secretary Finance.
Okay, that is one thing, but the thing is that whether any notice was issued to, notice was duly received by the earlier incumbent or not? Mr. Prokasta, you take steps?
If he is not there, my lord, if he is not there
Hmm.
at this point, my lord, we have to take steps upon the new incumbent. And in fact, my lord, another contempt case is there, 595/2024, where we have implemented this subsequent incumbent, my lord. It may come along with that, my lord, and that will cover same judgment.
No, is it a similar matter? Why should we
Yes.
club it together like
It's
that?
a similar, the same judgment, my lord.
Same judgment?
Same, another contempt.
What does the judgment say? Is a common order?
Yes, common order.
He's right, Mr. P.K. Bora, learned counsel, appearing for the respondent number 3. So means that the matter has been referred to the finance department. Finance, after that you put budget, within bracket. Finance, bracket, budget department. And pending a response, matter may be adjourned. Stop. No one appears for respondent number 2.
Just one Lordship, I can appear for respondent to your lordship for the finance department.
How will you appear?
Since there's no right now, but I can take notice, but
Now, how will you appear without filing vakalatnama? This is not a writ petition.
Yes,
This is a contempt petition. Notice no.
notice go, your lordship.
There is no representation from respondent number 2. Office to verify and put up a note as to whether notice has been served or not. List this matter again after 2 weeks.
Lordship, the name of finance department will be reflected in the cost list, your lordship.
This is not a regular finance department case.
Along with ballot contempt case number 595/2020.
Along with contempt case C number
595/2024.
595 of 2024.
A date may be given, my lord.
The registry will give it. What did I say? This again after 2 weeks. We act on a date to be fixed by the registry.
64.
Made please, my lord, here, my lord, main respondent, that is 6, 5 and 6, they have filed the affidavit, my lord, I want to file reply, 2 weeks time maybe.
As paid for by learned counsel for the petitioner. 2 weeks time is granted for filing rejoinder affidavit to the affidavit position filed by the respondents. List again after 2 weeks on a date to be fixed by the registry. Yes, next.
65.
Lord, instruction has been placed on instruction.
Now that the petitioner's name has been recommended, my lord, for promotion. Further 3 weeks time may be given, my lord, for the other formalities, my lord. Otherwise, partially complied with, my lord.
How is it partially complied with?
My lord, the second page, my lord, minutes of the meeting, according to parties of page.
Third page.
My lord, third page. Point number 1. A proposal of Dr. So-and-so.
On this serial number 1, isn't it?
Yes, my lord.
2 is somebody else.
Who is somebody else, my lord? This minor chota, so has been recommended, my lord. The petitioner now one formal order has to pass and then the for other benefits.
What was the direction?
The compliance report was to be brought into record, my lord.
No.
According to last.
Main judgment. Main judgment.
Main judgment.
Your good name?
MM Kashyap.
MM.
MM Kashyap.
NM.
MM.
I heard Mr. M.M. Kashyap, learned counsel for the petitioner, and Mr.
S. Das, Malad.
S. Das, learned counsel for respondent,
Sole
Which-
respondent.
for the sole respondent. Stop, Mr. S. Das, by producing
I'll be paying for 1 month. For me, what a director.
meeting minutes dated 21/7/2025 of the DPC. Held for considering the case of the petitioner, amongst others. Submits that the DPC has recommended the promotion of the petitioner from assistant professor stage 1 to assistant professor stage 2. Full stop. The learned counsel submits that pursuant to the said recommendation, a formal order will be passed, and for which he seeks some more time to get back to the court with the up-to-date status. Stop considering the above submission. Let the matter be listed again
After 2 weeks, Malad.
after 2 weeks on a date to be fixed by the registry. Stop a copy of the meeting minutes dated 21/7/2025 with the covering letter dated 22/7/2025 produced by Mr. S. Das shall be retained in the record and marked as X for identification.
Highly applies.
67.
May I please, your lordship? This is in contempt application, your lordship. 1 year back order has been passed, your lordship. Then your lordship may kindly come to page 18, para 25 onwards. I have challenged the appointment of the private respondent number 4 in the writ petition, your lordship, as principal IC, your lordship. That has been set aside by this honorable court, and director was directed to pass consequential order, your lordship, within 1 month from the date of receipt of certified copy.
Page?
Page 18, your lordship. Now they have taken too lightly the order of this honorable court, your lordship. It's deliberate, your lordship. In view of the conclusions reached by this court herein above, the order dated 6/1/2024 issued by the Director, Secondary Education Department, Assam, allowing the respondent number 4 in herein to hold the charge of the post of in-charge principal, Nazira Girls Higher Secondary School, Nazira, is set aside. In that view of the matter, Director, Secondary Education Department, Assam, is hereby directed to issue a formal order allowing the petitioner number 1 to hold the charge of the post of in-charge principal, Nazira Girls Higher Secondary School, Nazira. The Director, Secondary Education Department, Assam, in terms of the observation and direction passed herein above, shall now be required to pass the consequential order within a period of 1 month from the date of receipt of the certificate copy of the charge. Now 1 year has elapsed, your lordship. And this
Yes.
order is not to their liking, your lordship, therefore they are not complying.
Mr. B. Kaushik.
My lord, as per my instruction, my lord, on 25th, the petitioner will be called to the office for verification of some documents, my lord. More importantly, the age, my lord, because the rule stipulates, my lord, to hold the post of principal, one needs to be below 57 years.
Then they will have to file a review, your lords, of this order. Okay.
So what is the age of the petitioner? 57.
And for verification of that age, my lord, I have been told, my lord, that 25th, the petitioner will be called for.
No, that age, that particular age group required is 57 years and below. Or
Yes.
what?
Yes, not beyond 57 years.
Now supposing, what is the retirement age?
60. 60.
60. Supposing a person is given the in charge principal at the age of 56 and he continues,
So he may, because the
is it like that once he attained 57 years he'll be again
no
taken
on
out?
the date when he is appointed, he should not be beyond 57 years.
So this direction dates back to a certain date, or it's a new thing?
At the petition of is
See, not only the age as on today would be relevant. What would
in
be
fact,
relevant is
in
the
fact,
age.
the age on the date when the order was passed.
That
Even
was when? Respondent number 4 was given the in charge principal when?
He was given, your lordship, in charge principal, your lordship, 6/1/2024.
Where is that?
That, your lordship, it is not here, your lordship. It is part of the writ petition. Your lordship will get it in page 10. Judgment, your lordship.
6/1/24. Where's which paragraph?
Para 3, your lordship. The petitioners in the present proceeding have presented to challenge an order dated 6/1/2024 by which Director Secondary Education Department Assam allowing the respondent number herein to hold the charge of the post of in charge.
Okay. So what is your age today?
On the date of filing of this particular petition, your lordship, his age is 57 years.
Just 57. You don't have any particular date.
Date, your lordship, because that was not an issue, your lordship, therefore.
I understand it's not an issue, but just to make things clear and to make things clear also.
And in fact, your lordship, even if that is the ground, your lordship, they want to take in contempt, then they will have to file a review, your lordship. There is a specific direction by the
Yes,
Honorable Court.
Mr. Bothakur, I also understand that. Your contempt was filed on 16/8/24
Lordship, lordship,
by declaring you as 57 years.
maybe, your lordship.
Correct. So you had challenged in the writ petition the placement of the respondent number 4 as in charge on 6/1/24. If you are 57 on 16 August 24, then 16 January 24 also, I don't know, you might most probably be 57 or maybe less than that.
Lordship.
So your argument, or your submission, Mr. B. Kaushik, that we have to check his document to see whether he's less than 57 years may not be acceptable.
Well, that perhaps would be relevant, Miller,
It will be in reference.
there is a statutory bar, Miller.
I understand that statutory bar is there, no doubt. So going by that bar only, now going by that bar, somebody who was less than 57 years was kept out of the purview by appointing the respondent number 4 in the writ petition. Petitioner became successful. So court says that remove him and put now the petitioner.
The issue before the court in the writ petition was different, Miller. That the petitioner was not given the charge on the ground that he has acquired his qualification without obtaining NOC from the authorities.
Okay, that issue is no longer alive now.
Yes, that issue is no
Now you bring up another issue about age.
No, and
is that permissible?
This honorable court, while deciding the validity of not giving the in charge to the petitioner, took into consideration the ground for refusal. The ground for refusal apparently was that he has taken his qualification without obtaining in violation of Rule 13.
So that ground has been set at rest by not accepting it.
That was addressed, Mother.
Okay. So now can you bring up another?
That was the sole ground.
Okay. So now today, can you take another ground saying that even if you allow him this way, because of this reason, he cannot, without taking any recourse to any remedy available in law?
Once, if he is found that at that point of time, he was found that he did not have the adequate qualification to hold the post. So the other ground did not have to be ventured, because if first ground only he is he was found to be ineligible. Now court has held that no, that he has the eligibility, the educational qualification.
Your lordship will kindly see, your lordship, that.
So I am praying, my lord, let this matter come up after 25th any day, my lord. So 25th is the date, my lord, where he has been called for determining the, my lord, the age, my lord.
Your lordship will kindly see, had the honorable court directed that subject to fulfillment of other conditions, then your lordship, his ground, your lordship would have whole ground, your lordship. But the point is, your lordship, there is a specific direction that you set aside the order of the appointing respondent number 4 and appoint this person, the petitioner number 1, within 1 month from the date of the receipt of certified copy. Now, even if they have any ground, your lordship, they will have to come up with a review petition saying that these are the grounds. And this ground of age they have not taken in the writ petition also while filing their affidavit, your lordship. That is not their ground. Suddenly they have come up with a new plea, your lordship, since they don't like my face, your lordship. That cannot be, let them come up with a review petition saying that this is the ground on which we are not appointing him.
Don't give them any ideas.
But in fact, the cause of
They don't
action of
want to
review-
come. They
cause
don't
of
want to
action
come.
of review may come after 25 minutes.
At the end of the day, it's a holding of the principal in charge, your lordship. And therefore, your lordship, when this age is also there, your lordship, in the.
No, what happens when it comes to being on in charge basis?
Lordship.
If it's a substantive promotion or substantive appointment, then that criteria of being below 57, all that will come. Now, is it also applicable in case of an in charge?
Yes, my lord. Because in terms of the Jagannath Piku's judgment, my lord, if the criteria that is laid down for the substantive post would be applicable for in charge also.
Educational qualification, I can understand, your lordship.
But it says that is the qualification, the criteria, the eligibility that is required for an substantive appointment is also applicable for the in charge.
Supposing there is no eligible person, whether be age or qualification, then what happens?
But here the post of principal is a direct recruitment post.
Then what happens?
They will have to go for a fresh advertisement.
Until that fresh appointment has been made, what will happen? Somebody will have to take charge.
Somebody has to be given. Because it's a
The
temporary arrangement.
petition cannot be headless.
Yes.
So in that case, what happens?
In such cases, my lord, where there is no one in the school, the inspector is given the charge.
But they say, now they come and say again, inspector is not qualified.
My lord.
People will come again and say,
My lord.
inspector is not qualified. Why have you given him that charge?
No, because the inspector has the qualification of MA and BA.
How do you know that?
No, the qualification required to become an inspector is master degree and
Since
BA.
when? After amendment, I think.
No.
Prior to amendment, there's
Yes.
something else.
As per the Assam Education Service, my lord, the eligibility, the qualification that is required for.
So
To
we'll give
enter
you.
into Assam Education Service, they
Okay.
need 10 years of experience as a teacher and MA and BA.
So we'll give you a breathing space of 1 week. Thereafter, we'll see what can be
Yes,
done.
yes, sure. Top life.
Mr. B. Kaushik, Learned Counsel for the respondent submits that the petitioner has been asked to appear before the
The director of secondary.
Director of Secondary Education to examine his testimonials and other materials to see as to whether he is eligible to hold the post of in-charge principal of Nazir Girls Higher Secondary School, Nazira. Mr. S. Bortaku, Learned Counsel for the petitioner, on the other hand, submits that no stipulation has been made by this court while directing the respondents to place the petitioner as in charge principal in the order dated 13/6/2024. passed in WPC number 426 of 2024. And therefore, the respondents cannot put any other hurdle to prevent the petitioner from being the in charge principal. Be that as it may, since some time is being sought of, the respondent is given a week's time to come up with appropriate compliance instructions. List again on after a week on a date to be fixed by the registry.
You're also will fix a date, you're also, otherwise it's very difficult.
Registry will fix a date. Because if I fix a date, we might end up having like 80 cases like today. We don't want that. They will adjust accordingly, okay?
Obliged.
Thank you, Lord.
68 is complied.
Give to Mr. Patwar.
Yes, I have already given.
Copy, my lord.
You accept?
Yes, my lord, I have to pursue my other legal remedies now. my lord.
I see.
They have rejected the prayer, my lord.
By producing order dated, is right, by producing order dated 21/7/2025, passed by the Director, Secondary Education, Mr. B. Kaushik, Learned Counsel for the respondent submits that the direction of this court has been complied with. Mr. B.
J. Patwar.
J. Patwari, Learned Counsel appearing for the petitioner, submits, acknowledges to the said submission. In view of above, the contempt petition stands closed. Order dated 21/7/2025 produced by Mr. B. Kaushik is being retained in the report and marked as X for identification.
Deep level.
69,
So in this, I'm praying for 2 weeks' time for complete my instruction.
As paid for by Mr. B. Kaushik, Learned Counsel for the respondent, further 2 weeks' time is granted to receive complete instructions. Stop registry to list the case again after 2 weeks on a date to be fixed by it.
70,
Please, Your Lordship. Lordship, I'm praying for 2 weeks' time to file our affidavit function.
You are for which respondent?
For respondent number 3 and 4, Lordship.
3 and 4. So Saranya will give them some more time.
My lord, maybe that may be fixed, my lord, because
Date will come from the registry. Mr. M. Saranya, Learned Counsel appears for the petitioner, while Miss
V. Shohei, Lordship.
D. Saharia.
V. Shohei.
V.
Shohei.
V.
Shohei.
Shohei. Spelling?
How's the spelling?
Shohe.
Shohe. Miss V. Shohe, Learned Counsel appearing for respondent numbers 2 and 3.
3 and 4, Lordship.
Sorry, 3 and 4.
On behalf of Mr. J. Chuti.
It's okay. Praise for further 2 weeks' time to file counter affidavit. Up. Next, parent view of above. Registry to list the case in after 2 weeks on a date to be fixed by it. Stop the said respondents to file their counter affidavit in the meantime.
I love you.
71,
In this case, my lord, the petitioner, my lord, is the, my lord, mother, my lord, of the, my lord, government servant, my lord, who died in harness. Now, my lord, she was paid, my lord, the compassionate pension of rupees, my lord, 4 lakhs and odd. Then, my lord, she was sanctioned the provisional pension also, the regular pension. Now, my lord, in May 2023, a pension was stopped. And, my lord, she was asked to refund that compassionate pension amount she received.
What?
Compassionate pension amount that was paid, that she has returned. Now, my lord, in fact, there's a circular that they can opt between, my lord, either the compassionate pension or the regular family pension, my lord. And without, my lord, informing her, my lord, she was provided that, my lord, compassionate family pension.
But again, she was provided the provisional family pension also. That is the regular pension, but on a provisional basis. Then suddenly it has been stopped on the ground that she had already received the compassionate family pension amount.
Okay, so
She returned that money back. So now it is stuck up at that stage, my lord, because in the meanwhile, the government has come up with a circular saying that those who have not returned, those who are enjoying the money cannot refund it now, and my lord, they cannot enjoy the, my lord, benefit. But this lady had refunded the money earlier, prior to this notification.
no, I think we have come across with a similar case.
Well, here, my lord, I have not received any instruction from the authority concerned. I need some time now.
We definitely will give you time, plus listen out to me. Similar matter came up the other day. And there's some sort of an amendment wherein there's no time limit as such. There's no time limit. Earlier time limit was fixed within 6 months or something you have to, and within 3 months, whoever has to make a choice, whether you want to go for that or this. And ultimately, there's one amendment which says that there's no time limit. So if that is the case, then even if she refunds later on, she'll be getting that benefit.
In this case, she refunded earlier. She refunded earlier.
Must be.
Yes. I've given the challans also, an extra challans. They came earlier.
You're not aware about the amendment?
I'm not aware of that.
Just find out.
My lord.
There's an amendment which says that there's no such kind of bar.
Because I have another case, it's also there in the admission column today, my lord. There, my lord, she paid it late. My lord, she is yet to pay. But then they're not accepting the money because the time is gone. There I have challenged this circular. But here in this case, she had made the payment earlier, prior to this notification. This notification came on 27th of September 2024. And she
Page number?
Page number 50. Annexure 14.
50. Who died?
Her son, my lord.
Okay.
Late Ramanus Das, my lord.
Was working as what?
My lord, he was working, my lord, as assistant teacher, my lord, in this, my lord, Uttar 365 Uttar Badarpur.
Son was working.
Son was working.
And this is the mother.
Mother.
Please write down. The son of the petitioner who was working as assistant teacher expired while in service. And for that reason, compassionate family pension was given to the petitioner, who is the mother. Stop. However, the petitioner wishes to get family pension instead of the compassionate family pension, and therefore return the amount which was given to her
On 5/1/24.
on 5/1/2024. Prior to which date?
Prior to notification, my lord, dated 27th September 2024.
Prior to the notification dated 27/9/2024. Which is the clause which says that this is the time limit?
Yes, my lord, it says, my lord, withdrawal of the accumulated, my lord, para 2, my lord, para 2. In the event when the entire accumulated fund of the deceased NPS subscriber is withdrawn by the nominee, the same cannot be redeposited by the nominee and they will not be entitled to CPF, PPF. CFP, PFP. 2.1, 2. There's only one clause there.
What is CPF?
Okay, the CFP, my lord.
Compassionate family pension.
Family pension, my lord, and PFP, my lord, is PFP. It's my lord, the provisional family pension. My lord.
Provisional family pension.
But here in this case,
But can it be together like that? You had been given compassionate family pension.
My lord, because what, yes, my lord.
You don't want that, you want the family pension.
Yes, family
regular.
pension, my lord.
What did I say last sentence?
My lord, this is called my lord, there are two categories, my lord. One compassionate family pension, one regular family pension, my lord. Here the petitioner is paying for, my lord, regular family pension, my lord.
No, that's why.
Yes.
This CPF and PFP cannot be together. That's what I was thinking.
My lord.
What's the last line? Okay, like that. It's a continuation, isn't it? Full stop, then. Mr. P.K. Bora, Learned Study Council, Elementary Education Department, submits that he may be given some more time to obtain instructions in the matter. In view of above, the matter stands adjourned for 2 weeks on a date to be fixed by the registry. Mr. P.K. Bora, Learned Council, to come up with appropriate instructions by the next date.
But here, my lord, this notification was issued by my lord, public and pension and public grievance department. My lord. Regarding this notification, my lord, my friend is the competent person. My lord. He will.
My lord, actually, I have made a mistake, my lord. Here, what was paid to her is actually not CPF. It's called the annuity under the NPS. Annuity under the NPS. NPS, my lord, annuity under the NPS amount, my lord.
What annuity?
Annuity under NPS, my lord.
Where do you get that term?
My lord, that is there, my lord. That is there. Lordship will get the term. Because here, what they say, my lord, in the event where the entire accumulated fund of the deceased NPS subscriber is withdrawn by the nominee, that is the, my lord, NVT in the, my lord, they call it the NVT, my lord. And, my lord, that lordship will get it, my lord.
Page?
My lord, in that particular, my lord, page 50 itself, my lord, that is says that accumulated fund of the deceased NPS subscriber. And, my lord, page 50, my lord, it is say the entire accumulated fund of the deceased NPS subscriber. That is what she had got, my lord.
NPS means what? New pension scheme?
New pension scheme, my lord. So he was given that, my lord, the amount which was deposited under the new pension scheme. That was given to her.
I think this belongs to a different category. It's not about that compassionate family pension.
No, my lord. Then what has happened, my lord? The subsequent circular which came about, it provides compassionate family pension. That's a different issue from, my lord. That's under the old pension scheme. The compassionate family pension is with regard to those who die in harness, and for that remaining period of service which is left with them, my lord, they are paid the entire pension. So that way, my lord, they get the entire pension, my lord, the larger quantity amount, my lord. So what
Your case was NPS.
My case was, I was given the benefit under the NPS.
NPS.
Yes.
So NPS is a contributory nature.
Contributory nature. So
whatever you contribute and
Yes.
which is a matching given by the employer
Yes.
is returned to you
Yes. So I had the option.
as a one time.
Yes. So I had the option either to choose between the NPS or the family pension.
So where's that option?
That option that is to be exercised, but that option is there, my lord.
Where's the provision for
Yes, my lord.
exercising that option?
Yes, my lord. Yes, my lord. That lordship will find with the, my lord, office memorandum, my lord. Yes, my lord. Page 38, my lord. It starts, my lord, at page 37. Office memorandum, 18th of June 2018, my lord.
Page?
Page 37.
So,
Para 3, my lord. Para 3, my lord. The Director of Accounts and Treasuries, Assam Cum State Nodal Officer NPS, after receipt the Annexure T shall examine the claim in accordance with SWINSO guidelines and regulations issued by the Government of India and furnish relevant information in appropriate columns given in Annexure 1. The Director of Accounts and Treasuries, Assam shall also obtain from the Central Record Keeping Agency registered the NPS the information about the likely amount, monthly annuity amount with the accumulated pension, wealth in the subscriber account and recorded in the Annexure 1. The duly filled annexure, this shall thereafter be communicated to the appointing authority after affixing seal and signature. The appointing authority on receipt of the information from the Directorate of Accounts and Treasury shall forward the information to the claimant along with the family pension amount. So here the comparison is to be given. They are eligible to get so as to ensure that the claimant family member of the subscriber takes an informed decision in the matter of availing the benefits available to him, that is whether to offer the monthly annuity or additional benefits like family pension, disability pension, or as the case may be. So our case is, my lord, she was given, my lord, that subscription amount, my lord, under the NPS without giving her that option whether she wanted to opt for the monthly pension bill.
Okay, I had said something about refund, na?
Yes, my lord.
Just read that part, refund. Yes. No, that one, na? Just stop. And for that reason, compassionate, I said NPS, you write NPS was given. NPS was given to the petitioner. Then well, instead of that compassionate family pension, we have to replace it by NPS, new pensions. Then okay, we'll give them 2 weeks. Let's see.
My lord. And I'm sorry for the mistake I made, my lord.
Right, so item 71. Give me the file. Give the file.
80 of the supply list.
Met legal Lashud. Lashud, may I point out, this is civil bench 3 matter. Civil bench 3 matter.
That's item 80.
80.
Civil bench 3 matters.
Lashud.
Aganwadi.
Anganwadi.
This is what I thought also. It is submitted at the bar that this case is a civil bench 3 matter. Roman 3, civil bench 3 matter. Stop. As such, registry to list this matter before the appropriate bench.
Matters for admission, item 31.
Yes. No one? None appears for the petitioner when the matter is called. Matter stands adjourned for 2 weeks.
32.
May I please, your lordship? Lord, for the private respondent, my lord, we have filed our affidavit in opposition also. My lord. No,
Any interim order?
no, my lord. In fact, there is no, this is an direction was passed to amend the rate petition and subsequently amended petition has been filed, my lord. And we have also responded and affidavit in opposition has also been filed, my lord.
None appears for the petitioner when the matter is called. However, Mr. A.R. Bunel, learned counsel, appears for the private respondent.
My lord. Yes, so my friend.
The line for the petitioner, my lord. My lord, I think meeting has already been completed. So this is a challenge for termination from service, Hindi teacher.
When do we list it for admission hearing?
No, my lord, lordship may admit the matter and list it for a hearing.
Regular hearing.
No,
Hearing, my lord.
any convenient date, my lord, I am ready.
Is there any LCR required?
LCR has come, my lord.
LCR has come, my lord.
What is an LCR?
No, my lord, there is the order of the education tribunal is under challenge, my lord.
Yes.
That the education tribunal has been treated as a lower court record, my lord. My lordship is well aware, my lord, in the state of Assam, there is a direction for constitute the education tribunal for the purpose of, my lord, dispute the resolve the issues of Venture schools, my lord.
Maybe after 4 weeks, any day.
My lord.
The term of LCR has to be avoided now, it seems, isn't it?
My lord. Should be
TCR over.
ETC records, my lord.
TCR, trial court records.
TCR.
Instead of lower court records.
My lord.
You're Mr. Nath.
Yes, not.
Mr. S. Nath, learned counsel appears for the petitioner. And Mr. Who will appear for the state? Mr. D. Musari, learned standing counsel. Secondary education appears for respondent numbers 1 to 5. While Mr. A.R. Buhya, learned
8.
counsel, appears for respondent number 8.
8, my lord.
So it is submitted by the learned counsels for the parties that pleadings are complete and the matter may be posted for regular hearing. Next, in view of above, issue rule returnable by 3 weeks. Stop since parties are represented. No formal notice, no fresh notice is required. Stop registry to list the case for a regular hearing. When?
Urgency is on.
After
4 weeks.
4 weeks.
My lord. Oblige, my lord. My lord.
33.
May I please your lordship, as per earlier order, the respondents is supposed to file their affidavit, lordship, but till today they are not.
Lordship will file, lordship.
When?
Perhaps it was last listed in 2023, I think, lordship.
No.
Lordship may allow 2 weeks time, we will file. In
It
fact,
was last listed on 13/6/25.
25.
That time, Mr. A. Fukan had
Lordship,
played.
lordship, and he is preparing, lordship. I am told that he is preparing, lordship, so 2 weeks time.
How long, how much longer will he prepare?
2 weeks time, lordship.
Okay. Parties are represented by the respective councils as paid for by Mr.
A. Fukan, lordship may record. because
A.
he-
Fukan. Further 2 weeks time is granted
Lordship.
A date may be fixed.
for filing counter affidavit. List the matter again after 2 weeks
2 weeks, lordship.
on a date to be fixed by the registry. Okay.
Problem.
36.
May it please your lord.
Yes, Mr.
This
Malik.
matter, your lordship, basically, I would have argued the matter today, but it will take a long time with regard, and since already, therefore I pray that your lordship may fix it up 2 weeks.
2 weeks. Mr. Vaimanan, learned counsel for the petitioner, submits that the pleadings are complete and the matter can be taken up for admission hearing. To stop in view of above, let the matter be listed again after 2 weeks for admission hearing on a date to be fixed by the registry.
Much of this.
37 to 47.
Lordship, regarding this series matter, I am seeking a short accommodation, Lordship. I apologize to the learned counsels as well as your Lordship. Lordship, the main counsel who is arguing this matter on behalf of the Srimanta Sankadev University of Health Sciences. Lordship is not in station, Lordship, because he had to leave out the station because of some personal difficulties.
Who is the counsel?
Lordship, it's Counsel B. Gogoi. In the morning, I could not get a hold of all the counsels. That is why I'm apologizing to them.
No,
Also,
not
not
actually, many councils are there, so
Yes,
perhaps
sir.
my learned friend could not apprise the everyone. Affidavit has not yet been filed, Milo.
B. Gogoi is for which respondent?
For the health department, Milo.
Oh, health department.
My lord, this is a pharmacy council case, Milo. So, no, affidavit is very much warranted, my lord, but till
Who will file affidavits from whom?
from the health department, my lord, from the Shankar Deva University.
What is the matter regarding?
Lord, the outside, the person, my lord, who has obtained the degree, my lord, from the outside universities, not from the Shankar Deva University, my lord, they are again forced to appear in an examination, my lord, before going to be enrolled under the Assam Pharmacy Council. So that policy.
To be a pharmacist.
My lord, we have that degree of B Pharm and D Pharm, my lord.
For enrollment of pharmacist, you are again asked to be undertake one more exam.
Examination, my lord. So that is under challenge, my lord.
Who will conduct the exams?
That Shankar Deva University, my lord. Lord,
Shankar Deva.
My lord, Shankar Deva University, my lord.
A
My lord,
particular university has been designated.
yes. No, it is their suo moto. It is not been designated by the Pharmacy Council of India, my lord. It is their suo moto decision in the state of Assam.
Of the health department.
My lord, my lord.
Otherwise, your pharma thing, B Pharm
B Pharm
degrees from.
From other universities, my lord, various universities, my lord.
So what is the bar?
Bar, my lord.
What is the bar?
Because, my lord, we
They don't accept.
Because, my lord, the Pharmacy Council of India, the universities from where we have obtained the degree.
Is affiliated.
Affiliated by the Pharmacy Council of India, my lord. That's why, my lord.
So, but still they don't want your.
They don't want to get.
Unless you go through the test.
My lord.
No affidavit filed?
No, my lord.
What to do then?
Lordship may just keep the matter pending. Lordship may list it immediately after next week. By that time, he will also be here. He'll be able to apprise the court as to what is the present status of the particular matters.
Is right. Although the counsels for the petitioners are present, Mr. B. Gogoi, learned standing counsel for the health department, is said to have some personal difficulties to appear before the court today. Stop on a prayer made on his behalf. Let the matter be posted again. After a week?
After a week.
After a week? On a date? On a date to be fixed by the registry. On a date to be fixed by the registry. They'll give a date.
Much better.
Obliged, my lord. Highly obliged.
48 and 49.
None appears for the petitioner on the matter called. Petitioners, yes. Forensic of Justice. Are they? You are there. Who's appearing? 48, 49.
Lordship, the state respondent are supposed to file their affidavit, Lordship.
You are appearing in this case? 48, 49.
No, for the petitioner, Lordship.
Still the order.
Yes, yes.
Mr. N, Miss N. Phukan has not filed. Elementary. Elementary. Who's there for elementary education? Mr. Pegu, you're there?
Yes. Kindly grant 3 weeks time for filing affidavit.
3 weeks time was granted on the prayer of Miss N. Phukan last time. She said, submitted that she had received instructions. That was in May 21st. We are in July now. Who's handling this matter?
N. Phukan is
Huh?
N. Phukan is sending me.
Although 3 weeks time was granted to the respondents for filing counter affidavit on the prayer made by Miss N. Phukan, learned standing counsel, Elementary Education Department, no such affidavit has been filed till date. To stop on the prayer of Mr. G. Pegu, learned standing counsel. You are also elementary.
Yes, sir.
Elementary Education Department. Further 3 weeks time is granted. List again on after 3 weeks on a date to be fixed by registry.
Lordship, date may be fixed.
Registry will fix the date.
Okay.
50. My lord, here we have received our instructions and we are preparing our affidavit, your lordship. Kindly grant us 1 or 2 weeks time.
You are Miss
H. Terangpi, your lordship, for the secondary department. H. Terangpi.
Miss H. Terangpi, Learned Standing Counsel, Secondary Education Department, submits that she has received the instructions and she will be able to file the affidavit of possession within 2 weeks' time. Stop.
They have already filed one affidavit now.
In view of above, registry clears the case again after 2 weeks on a date to be fixed by it. Stop. In the meantime, counter affidavit should be filed. Your good name?
FL Oscar.
Mr. F.L. Oscar, Learned Counsel, appears for the petitioner. Petitioners.
Obliged. 51.
My lord, here I'm praying for 3 weeks time to receive instruction. Praying for 3 weeks time to receive instruction.
Education supposed to file affidavit in opposition, lordship. Respondent of other respondent file regarding pension of the petitioner, unmarried sister, lordship.
My lord, here to receive instruction. Kindly give 3 weeks time.
How are the respondents?
Elementary education.
How many respondents are there? 6 has filed, seems.
Yes, lordship.
Treasury
6
officer.
6 already filed.
Affidavit, we are justifying our claim for not granting her the compassionate family pension.
And director of pension? Have you filed?
Only respondent number 6 filed.
As paid for by the learned counsels, they're paying for respondent numbers 1 to 5. How much time? Further 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks on the date to be fixed by the registry.
And replay of this.
52.
I don't think, I guess, I is not, I think both ways is. That is why kindly pass about this method for timely.
Who is the engaged counsel?
Sabasasi also.
Huh?
So SP Sodu.
SP Chaudhary. Yes. Out here also, Mr. Pegu.
Yes, my lord, department can refer to SCRT regarding ascertain the basic training or ceremony. So matter is under consideration. Very good.
So you want some more time?
Yes.
Mr.
Dr. B.N. Chandra, B.C. Bora.
Dr. B.C. Bora, Learned Counsel, appears for the petitioner. While Mr. G. Pegu, Learned Standing Counsel, Elementary Education, appears for the respondent numbers 1 and 3 to 6. 1 and 3 to 6. Okay. 2 6 means TO2. 1 and 3, 3 to 6. Mr. Arbor Puchari, Learned Counsel, appears for the respondent numbers 2 and 7.
2 and 7, my lord.
Stop. Mr. G. Pegu submits that he may be given further 3 weeks' time to obtain instructions and to file counter affidavit. Prayers allowed. Finance, anything you?
Yes, my lord, our instructions are already there on record with a flag Y, my lord, mark Y. Petitioner is seeking, my lord.
There's only one flag.
My lord, by
There's
order,
no Y also.
by my lord, by order dated, my lord, 23rd of April, 23/4/2025. 23/4/2025, if lordship says make order, my lord. Now here in this case, my lord, the petitioner is seeking the benefit of, my lord, the judgment passed by this honorable court, my lord, in the case of Purnima Hore. And I think, my lord, the issue therein was, my lord, whether the petitioners falling under the category of stipendiary teachers would be covered under the old pension scheme or the new pension. So this honorable court in Purnima Hore judgment, my lord, held that the category of teachers which fall under the category of stipendiary teachers, they will be entitled to the old pension scheme and the not, my lord, the new pension scheme. Accordingly, that writ petition was closed and all the stipendiary teachers, whosoever may be, whether they were the writ petitioners in that writ petition or not, they will be given the benefit of OPS. Accordingly, my lord, he has stated that since he being a stipendiary teacher, he is entitled to the benefit of that decision. Now, for that verification purpose is to be done by the education department. This is what our instruction says, which is placed on record. Because finally we have to take a call, but the data has not been provided to us.
In view of above, list the matter again after 3 weeks on a date of to be fixed by the registry.
Highly obliged.
I'm so obliged.
53.
May I take note? In this case, my lord, I am appearing for respondent note 3 and 6, my lord. 1 week time may be given for filing affidavit. Almost affidavit is ready, my lord.
My lord, I
will-
don't
I will
understand
understand.
what is the purpose of the principal and the governing body in pension case, my lord. I was the principal of that college. I retired on, my lord, 31/3/2024. They have not sent the papers to the department for last 1.5 years, my lord, only to harass me. Because the, my lord, president of that governing body, who was contended for the post of principal, and he failed, thereafter become president and trying to, my lord, sit over me. And now after my retirement, they are harassing me. What is this, my lord?
No, my lord, actually.
My lord, there is no
yes,
provision for keeping,
Yes.
at least for the, my lord, the provisional pension they could submit if there is any proceeding. This is the circular of the government, my lord, 19/12/2023, where it is said, if you cannot submit the proposal for pension, regular pension, you have to submit the, my lord, you have to submit the provisional pension proposals, all the documents. They are not sending it for less than 1.5 years. Now they are saying, what is the, why the affidavit is this? I don't understand.
My lord,
It is the government who is to take the, my lord, call whether pension will be given to me or not. It is their duty to just to forward the documents. They are not forwarding.
my lord,
Yes.
I don't
my lord,
understand.
Why
he has-
are you
he
not
has-
forwarding?
He has misappropriated 45 lakhs.
No,
on
who
this.
is he to
And-
say?
and
It
he
is
has-
the government to
and-
say.
And he has returned 11 lakhs, yet 34 lakhs is the liabilities, my lord.
My lord, that allegation was there. They tried to, my lord, tried to bring that allegation. We challenged the before dishonorable court. Dishonorable court stayed all those proceedings, my lord.
1 week time may be given, my lord.
I am not on that, my lord. At least if I am not entitled, it is the government to decide, my lord. I have no issue. What is the problem for sending them, my lord? This is, your lordship may kindly peruse this order of this, my lord, the government. How can they stay without sending the documents, my lord? Your lordship may kindly see the next. If there is any proceeding, criminal or departmental proceeding, for whatever reason, if they cannot send the, my lord, pension proposals, they have to send the provisional pension proposal. They cannot keep it.
Please write down. Non-forwarding of pension proposal by the college authorities has led the petitioner to file the instant writ petition. Mr. J. Payam, learned counsel for the petitioner, submits that the petitioner retired as
Principal, my lord, not working.
principal of North Guwahati College on 31/3/2024. But the respondent authorities have not taken any initiative to pay the pension, GPF, GIS, gratuity, leave encashment, etc. to the petitioner till date.
My lord,
No.
the principal also sent a letter to the director for regarding his pension, my lord.
He submits that as per the instructions issued by the Director of Higher Education on 19/12/2023 to all principals and all provincialized colleges Provisional pension proposals are to be sent to the directorate for the cases whose regular pension proposal did not be processed directly by directly to the Accountant General Assam due to special circumstances. Stop. Despite such instructions, no steps have been taken by the authorities concerned.
Respondent number 3 and 6. They have to send it.
Particularly respondent numbers 3 and 6. Yes, what is this? Review.
My lord, principal also wrote a letter to the director, my lord, as the liability is there, my lord. So what step is taken by the?
What is the response?
My lord,
What is the reply?
reply has not come from the director, my lord.
This is already October 24.
Not my lord.
Pensions,
No, you wanted some time for what?
My lord, for filing affidavit, my lord. On Monday, my lord, I will file it. Next week, this matter may come.
Mr.
S. Rahman.
S.
Rahman.
Rahman, Learned Counsel,
For response 3 and 6.
appears for respondent number 3 and 6 and submits that the counter affidavit is under preparation and he will be able to file the same within 1 week from today. Who's,
Lordship, Didas on behalf of B. Sharma, standing on respondent number 5.
yes, what is your submission?
Yeah, Lordship, once we get the papers from the department, concerned department, we'll do the need from Lordship. GPFA and legal entity.
Even though, my lord, there is any departmental proceeding, those cannot be kept pending.
That is true, my lord. But
I have no problem, my lord, if they make inquiry, whatever, under the process. But at least they have to send the provisional pension proposal.
In view of above, list this matter again after a week on a date to be fixed by the registry. Mr.
Didas.
Didas, Learned Counsel, appears on behalf of
So B. Sharma.
B. Sharma, Standing Counsel, AG Assam, who appears for respondent number 5.
Have entered the provisional pension papers in this. I am not asking for regular pension, whatever other. This matter, the person who has retired before my lord, 1.5 years without any single penny. So what is the? I don't think, my lord, there is any bar in sending the provisional pension. I'm not for regular pension and other.
Next para, having regard to the fact that the petitioner has retired from service.
Thirty-one, 3/2020.
More than 1 year back, the respondent authorities concerned shall take necessary steps for forwarding the proposal for provisionary pension without delay. Yes.
Small pension, right? When come with along with 71, which are taken up by Lordship. Same, almost similar matter.
54 with 71. As paid for by Mr. M. Datta, Learned Counsel for the petitioner, list this matter along with WPC number 1580 of 2025.
55. Your lordship, we have received for instruction yesterday, your lordship. So we'll be filing our affidavit, your lordship.
Miss
H. Terangpi.
H. Terangpi,
For all, yes, your lordship.
Learned Counsel for all the
the
respondents, submits that she has received the instructions and requires how much time?
3 weeks, your lordship. We have received it yesterday, your lordship.
3 weeks time to file the counter affidavit. Stop considering the submission. List this matter again after 3 weeks on a date to be fixed by the registry. Stop the respondent shall file the affidavit of possession in the meantime with a copy to the other side.
Obliged, that.
Completed. Somehow we completed.